Oh. What's oh my God. Dad, on his way down. Yes, oh, you were like today, Jack. You went check? Yeah, I saw your bag.
One. Good to go.
When I feel ready, maybe I will put the self is the car.
Hey, where's you?
Oh, thank you.
Oh, okay. Good morning, Yolanda. You good to go?
Whatever you want. Whatever you want. So.
You can Photoshop Brad Pitt's picture over. No?
That's what we call it. Or supposed to be. I'm sorry, what do you need? Thank you. I got email about a space. Oh, yeah, that's it. So, okay, hang on, some of the things. You know, we have to, I have two add-ons from state.
For felonies or?
DD. Okay. I do not have. We don't have. They never received. Right, just give me a second, I'm putting the practice and stay away together.
Okay.
Okay.
Did you have week one yesterday?
I did.
Glad to be back.
Good.
So I'm gonna be.
So you only have to do one day on the weekends?
Everything does only one way. That's not right. It's what they need. Yeah. Overnight. No, I didn't get that. No, I have a good one. Okay. Well, we gotta have
That one Halloween.
that Halloween. Yeah.
Thanks.
Stay over state, help me out and be specific. What conditions apply? Yesterday I come messed up. I'm a few. Good one.
So you get a chance to drive for a couple past.
Are you here all day? State?
All right, yes, sir.
Okay, can I get your names?
Making coffee.
I just chat one.
His name's D-O-U, is it like cough?
Coffee.
L-I-N?
L-I-N. Exactly.
And your name?
PHAD, first name and then last name is LYO.
Lyle.
Yes. I have two first names. I never want to go with the first name Lyle. So
You've never heard of Lyle Lovett?
Which one?
446.
I yes. I didn't go.
Thank you.
You're welcome.
Oh, very.
Okay, so the back.
Thank you so much.
You're welcome. Promise. Promise.
Yes, we're waiting on the public defender. Yes.
Where's my heart? I wanted to mental environment. Okay, tell my secret. I will. So you come back, I'll meet you. Yes. I'm looking at you.
Do we have corrections is ready?
They're bringing them here right now, George?
Okay, so I'll wait.
What time is it yesterday?
4. We had a lot of phones.
Oh, yeah. How much is a lot?
It seemed like a lot.
Oh.
It seemed like more.
It was. That was why I did that. Like, I did this one, so I'm different. You just have a reason working. I don't have that. They have more. Oh, okay. What?
So completely, you know, out there.
I will. But, well. That's all. Like, I try to go home and call somebody. Okay, what else do you have? I can't.
I got you. Stay with her for 1.
Okay, we can. Oh, I can stand on. Okay, this is number 2 and 3. Sorry, this is number 2 and 2.
Good morning, corrections. Is everybody here?
Good morning, we can start.
And I have all of the defendants, please stand and raise their right hands.
Todos pónganse de pie y levanten la mano derecha.
Do you swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? Please.
¿Juran decir la verdad, toda la verdad y nada más que la verdad? Por favor, digan lo juro.
Okay. First case I'll have on the jail arraignment calendar for domestic violence is Courtney Politis. Madam Clerk, do you want me to mark on the docket or are you gonna mark it?
You can judge whatever you.
Okay.
And I'll just tap your name.
Okay, Ms. Politis, you're charged with battery, misdemeanor battery. The court finds that there's probable cause. State, what is your position on bond?
Good morning, Your Honor. ASN Megan Kaufman on behalf of the state. The defendant does not have any local priors. We're asking for a $1,000 bond. It's ASA Megan Kaufman. She has no priors. We're asking for a $1,000 bond.
Okay, the court will set bond at $1,000 and you can be entering a stay away order. Good.
Judge, can you hear me?
Yes.
Public defender here to document. Why does this Politis having no power?
I'm sorry. I have a really bad audio connection. I can't make out what the public defender is saying. Okay, thank you.
Can you hear me now?
There's a bad echo.
Well, I'm gonna have to advocate for my clients, so I'm gonna ask corrections to see what they can do to.
I can hear you now.
You can hear me now? Okay. So Judge, we'd be requesting that Ms. Politis be released on her own recognizance in light of her having no priors.
Okay, well, the court is gonna set the standard bond in this case $1,000 and enter the stay away order against favor of Nick Politis. You to have no contact with him, ma'am, during the pendency of this case. If you reside together, you're gonna have to have the police escort you to the home to remove your belongings until you can resolve this case. Daniela Rodriguez. Ms. Rodriguez, you're charged with battery.
Okay.
Court finds there's probable cause. State, what's your position on bond?
We were unable to pull the defendant's priors because it was an add-on and our system is currently not working. So we're asking for a $1,000 bond.
Judge, Assistant Public Defender, I don't see any priors. In light of that, we'd be requesting that Ms. Rodriguez be released on her own recognizance.
I'm going to set the standard bond of $1,000. And I'm going to enter a stay away order in favor of Ryan Adams. Ms. Rodriguez, you have no contact with Mr. Adams during the pendency of this case until this order is dissolved or dismissed by another judge.
Hamilton. Lou Hamilton. Hamilton Daniel.
Your Honor, Ms. Hamilton is Ward D reset for tomorrow.
Which case?
Hamilton Daniel. He's Ward D reset for tomorrow.
You have his court test reset tomorrow?
No. She's saying this one is supposed to be reset tomorrow, but we're here right now.
Okay. There's like a really bad echo going on here for, I don't know if AV Tech can help us out. Okay.
The judge said he had bad feedback on his end.
Manuel Nieves Cortez. Do we have Mr. Cortez?
I'm sorry, Your Honor, what's the defendant are you calling?
Manuel Nieves Cortez.
He's coming up, Your Honor.
Okay, thank you.
No. Well, you just have to speak into.
Okay.
No, right here, stand there, right here.
Are you still hearing feedback?
I think it's better. It was an echo. Let's try it with Mr. Nieves Cortez.
Yes, Judge, he's present.
Mr. Nieves Cortez, you're charged with domestic violence battery. The court does find that there's probable cause.
Judge, we would be requesting the services of a Spanish interpreter for Mr. Nieves Cortez.
Spanish
Hold on.
interpreter present.
We were both talking at the same time, so I couldn't hear either one of you. So state first, and then let me hear from the PD.
Okay. First interpreter, Judge. One moment. Señor Nieves Cortés, a usted se le acusa de un cargo de agresión física de violencia doméstica.
Ajá, sí.
Yes.
Yes, sir.
This was another add-on case. We were unable to pull the defendant's priors. We are asking,
Este es un... I'm sorry, go ahead, State.
we are asking for a $1,000 bond.
Este es un cargo agregado y no pudimos sacar los antecedentes, entonces estamos solicitando una fianza de $1,000.
Yeah, the court does find probable cause for the battery. Mr. Nieves Cortez, I'm going to set your bond at $1,000. I'm also entering a stay away order. You are to have no contact with the alleged victim, Marlene Medeiros. If you live together, you're going to have to find temporary residence somewhere else. You can only return to the property if accompanied by a police officer to retrieve your belongings until this case is resolved.
Bien, señor Nieves, hay que sí existe motivo fundado por el cargo de agresión física, violencia doméstica. Voy a asignarle una fianza de $1,000. También le voy a poner una orden de alejamiento. Usted tiene que mantenerse alejado de la presunta víctima Marlene Medeiros. Usted no puede tener ningún tipo de contacto con ella. Si viven en la misma casa, usted tiene que buscar vivienda temporal y no puede regresar a la casa de ella, sino hasta que sea hecho acompañado de la policía para retirar sus artículos personales, y eso lo puede hacer solamente una vez.
Okay.
Okay.
You said Daniel Hamilton?
Hamilton.
Is that the one being reset?
Yes, Your Honor, that's reset Ward D.
Or D? Okay.
English is good. This one, I'm good.
Adam Daniel Baez?
Yes, sir.
Good morning.
Oh, good morning.
Domestic violence battery. Let me look at the arrest affidavit. All right, this court does find probable cause. What is your position on bond, state?
The defendant does not have any local priors, but given the facts in the arrest affidavit, we're asking for a $2,000.
Defendant,
Judge, in light of Mr. Baez having no local priors, we'd be asking that he be released on his own recognizance. Alternatively, we'd be asking for a $1,000 bond. This appears to be a domestic dispute blown out of proportion, and he doesn't have a history of other batteries committed against the alleged victim.
I am going to set the standard bond of $1,000. I'm also going to enter a stay away order. Mr. Baez, while this case is pending, you have no contact with Khan Yasmin. So if you were living together, you're going to have to find somewhere else to live, and you cannot return to the property unless escorted by a police officer to retrieve your belongings.
All right, good luck. Thank you.
Rosel Giovanni Montez.
Morning, Your Honor.
Good morning, sir. You're charged with a battery.
Correct.
The court does find probable cause. State.
The defendant does not have any local priors. We're asking for a $1,000 bond.
If the court does find that the $1,000 bond is appropriate, I'll enter a stay away order. Mr. Montez, you have no contact with Crystal Revius during the pendency of this case until a judge either dismisses this case or rescinds or amends this order. So if you were living together, which it appears you were, you'll have to find temporary housing elsewhere. And to retrieve your belongings, you'll have to have a police escort.
Understood.
Jonathan Thomas,
Yeah, I am.
good morning. Sir, you are charged with a battery.
We'd be requesting the Spanish interpreter, Your Honor.
Okay,
Señora, ¿usted se le acusa de un cargo de agresión física?
Físicamente,
No tienes que responder.
no.
solamente, okay. The court does find that there's probable cause. What is your position on bond, state?
Hallo que sí existe motivo fundado, fiscalía.
The defendant does have an M21 battery that has the DV indicator, pausing for interpretation.
El acusado tiene un cargo, un delito menor del 2021 que tiene que ver con agresión física, violencia doméstica.
That case is not with the same victim.
Ese caso no es con la misma víctima.
We are asking for a $1,500 bond.
Estamos pidiendo fianza de $1,500.
Your Honor, the case the state is referring to was no actioned, so there was no conviction involved. It does not involve the same victim, so we'd be requesting that Mr. Thomas be released on his own recognizance or alternatively granted a $1,000 bond at the standard amount.
Su señoría, este cargo que está mencionando la fiscalía es un cargo que no procedieron con ese cargo, o sea que no hay una condena en ese cargo y tampoco es con la misma víctima. Estamos solicitando libertad bajo palabra o en su alternativa una fianza de $1,000.
Okay, the court is going to set bond at the $1,000 and enter a stay away order. Mr. Thomas, You're just have no contact with Madeline Reyes during the pendency of this case until this order is dismissed or otherwise amended.
Señor Thomas, entonces voy a emitirle una fianza de $1,000. También se le va a dar una orden de alejamiento. Usted no puede tener ningún tipo de contacto con Madeline Reyes hasta que esta orden haya sido retirada o enmendada.
If you're living together, you're going to have to find another place to live temporarily until this resolves.
Si están viviendo juntos, va a tener que buscar otro lugar donde vivir temporalmente hasta que esto sea resuelto.
And you will have to have a police escort if you want to retrieve your clothing or other belongings at the residence.
Y si usted quiere retirar sus artículos personales como su ropa o cualquier otro artículo personal, usted tendrá que hacerlo acompañado de la policía.
Okay.
Ya es todo.
Luis Armando Aguilera Gomez.
Mr. Aguilar Gomez has a hold for immigration.
He has an immigration hold.
Yes, Judge.
Good morning.
Good morning, Mr. Aguilera Gomez. You're charged with battery. Let me look at the arrest affidavit. Is there any argument of probable cause defense?
Judge, I would argue that this was parental discipline, which is a well-established doctrine within our legal system, and the police intermeddling with that is overstepping their authority.
Trying to see how the police were dispatched. What's your position, state?
You're not Luis.
So the
No.
defendant exceeded the
Judge,
limitation.
I apologize. Are we discussing Luis Armando Aguilera Gomez?
Correct.
The defendant next to me is someone else.
Oh,
What's your name?
My name is Christopher Martinez.
What? Get out there. I-
My apologies, Judge.
no worries.
What's your name?
This is what happens when we lose 1 hour of sleep, right?
We're all feeling it. Wendy, Español. And we'd be requesting the services of the Spanish interpreter.
Interpreter present.
We are going to start over. Good morning, Mr. Aguilera Gomez. You're charged with battery.
Buenos días, señora Aguilera Gómez. A usted se le acusa de un cargo de agresión física.
Your attorney has made an argument on your behalf challenging probable cause. I'm going to hear from the state attorney.
Su abogado ha hecho alegatos a favor suyo, argumentando en contra del motivo fundado. Voy a ver qué dice la fiscalía.
The A form specifically states that the defendant exceeded the limitations of corporal punishment and that there were visible red-colored welts on the victim.
En el affidavit de arresto dice que el acusado se excedió a los límites corporales permitidos y que había marcas rojas visibles.
It is the state's position that the specific statement that it exceeded corporal punishment is enough to find probable cause.
Y la fiscalía dice que esta declaración que dice que se excedió en el castigo corporal es suficiente como para motivo fundado.
Yes, it's a question of degree, but the court will find probable cause. But I think this is the defendant that has an immigration hold. Is that correct?
That's correct, Judge.
Okay.
Bien, yo hallo que sí existe motivo fundado, aunque entiendo que esto depende del grado de la situación, pero el acusado también tiene una detención de inmigración.
I'll set the standard bond of $1,000 on this case, but Mr. Aguilera Gomez Corrections tells me there's a hold from immigration. So even if you post bond, I don't think you could get released.
Señora Aguilera Gómez, le voy a fijar una fianza de $1,000, pero los del Departamento del Correccional me dicen que usted tiene una detención de inmigración, o sea que aunque usted pague esa fianza, no creo que lo dejen salir.
Your Honor, I'm not sure if this changes in the domestic violence context, but for misdemeanors, whenever clients have ICE holds, they're usually granted a dollar bond. I just wanted to put that on your radar.
Su señoría, normalmente cuando los clientes, esto es un cargo de violencia doméstica, pero cuando son delitos menores, normalmente se les impone una fianza de $1 cuando tienen una detención de inmigración.
I'm gonna remain the bond at $1,000. With respect to the stay away order, this is his daughter. There's a question of the degree of discipline, so I'm gonna let him have contact, but he cannot be violent towards the victim in any manner.
Bien, entonces voy a dejar la fianza en $1,000, pero con respecto a la orden de alejamiento, esta sería contra su hija. Entonces, como hay duda en cuanto al grado del castigo, lo que voy a hacer es que voy a permitir que tenga contacto, pero este contacto no puede ser violento.
Buena suerte.
Correct, that's what I was, and then I think, I guess, if there were to be a dependency division case, that would trump this case. Under number 7, if you read that,
That is correct, Your Honor.
so I'll check 7.
No, no sé inglés.
We're going to need the Spanish interpreter for Mr. Alvarez.
Yo le voy a servir de intérprete, señor Álvarez.
Francisco Alvarez. Mr.
Yes.
Alvarez, you're charged with assault on a person over the age of 65. The court,
Señor Álvarez, I'm sorry, go ahead, Judge.
the court is going to review the arrest affidavit.
Señor Álvarez, a usted se le acusa de un cargo de intento de agresión contra una persona mayor de 65 años. Voy a revisar el affidavit de arresto.
No, no, sí,
No, señor, solo le estoy diciendo lo que dice el juez.
No responde, no contesta.
Court does find probable cause.
Hallo que sí existe motivo fundado.
State, you want to address the bond issue?
Fiscalía.
The defendant does have 3 prior DV cases, all with the same victim.
El acusado tiene 3 cargos anteriores de violencia doméstica, todos con la misma víctima.
There is an F-22 battery on an elderly person that was no action.
Hay un cargo de un delito mayor del 2022 contra una persona mayor de edad. Ese caso no procedió.
An M09 battery that was null pros.
Un cargo de agresión física, delito menor del 2009. Ese caso se desestimó.
And an F12 battery that was no action with the same victim.
Y un caso de, I'm sorry, State, can you repeat that? It was a MO?
M12 case battery that was no action with the same victim.
Un caso de un delito menor de agresión física es con la misma víctima y ese caso no procedió.
Given the priors, we're asking for a $2,500 bond.
Dado estos antecedentes, la Fiscalía está solicitando una fianza de $2,500.
Defense, would you like to say anything?
Your Honor, considering that the priors listed by the state were no actioned and in all candor, Mr. Alvarez's only conviction is a petty larceny, which is a local ordinance back in 1998. We'd be requesting the standard bond at $1,000.
Su señoría, estaríamos solicitando una fianza estándar de $1,000, considerando que los casos anteriores que ha mencionado la Fiscalía no procedieron a juicio con esos cargos. Y también, con toda honestidad, su señoría, el único cargo que tiene el señor es un cargo de hurto de menor cuantía. Por ese motivo pedimos fianza de $1,000.
But given that this is a domestic violence battery, the court finds a $2,500 bond is reasonable in light of the prior arrest with involving the same victim. I'm also going to enter a stay away order. Mr. Alvarez, in the event that you do bond out, you have no contact with, I assume this is your father, Francisco Alvarez.
Señor Álvarez, dado que este es un cargo de violencia doméstica, agresión física, voy a imponerle una fianza de $2,500. Me parece que eso es razonable dado los antecedentes. También, señor, y por lo que han sido con la misma víctima. También, señor Álvarez, usted tiene una orden de alejamiento, dado el hecho de que usted llega a salir de la cárcel. Usted no puede tener ningún tipo de contacto con el señor Francisco Álvarez, que supongo es su padre.
Judge, that was $2,500 bond, correct?
Correct. Corrections, $2,500. Did you bring me anything?
Dinero si yo pagué la renta del vivo con mi papá y él es que está buscando el problema y yo me quedé pasmado. Yo no tengo dinero.
Judge, would you be willing to provide pretrial services as an alternative?
Señoría, ¿podría otorgarle servicios previo al juicio como alternativa?
The issue of defense is, the A-form says he lives with his father. Where would he reside if he was released to pretrial services?
Aquí dice que él vive con el padre. ¿Dónde viviría él si es que lo llegaran a dejar salir de la cárcel?
Porque discutir yo no me hice nada. Mira, si mira, yo soy el que estoy confiando.
In that case, Judge, we will not be requesting pretrial services.
Yo puse todo el dinero, los 700 y pico, lo di para la renta.
Después hablamos de tu caso.
Remain
Buena suerte, señor.
$2,500 corrections. Christopher Valentin Martinez. Good morning, sir. You're charged with battery and petty theft. The court will review the arrest affidavit. Good morning.
Anthony Gill, I'm here on a matter for the state.
Okay.
I'll sit patiently.
Okay, the court finds probable cause. State, let me hear from the state on bond. I do see a criminal history with a lot of driving offenses, but also some batteries.
The defendant does have a significant DV history, all with the same victim. There's an M24 battery that was no action, same victim. An M23 battery that was no action, same victim. An M22 battery that was no action with the same victim. There's an F17 robbery, strong arm attempt, and a battery by prior convictions. Those were convictions with the same victim. An F16 battery and resisting without violence. Those are with the same victim. Those are also convictions. An M15 attempted battery conviction with the same victim. An M15 PTR violation, that was a conviction with the same victim. An F12 battery along with other charges, the battery was with the same victim, conviction. And there's also 9 different probation violations in his local priors. So we're asking for a $5,000 bond and a GPS level 1.
Defense.
Your Honor, as to the petty theft, Mr. Martinez only has 1 conviction from 2012, is my understanding.
We're looking at a domestic violence case where the defendant has a history of at least arrest with the same victim, which is a mother, I think. Is that correct, State?
I will double check.
At least I think that's what it is on the A form.
Yes, Judge. And the vast majority were no action, so we'd be requesting that those not be held to the same level of scrutiny as his convictions. And we'd be requesting the standard amount of bond. As to the probation violations, probation is an insurmountable task for a lot of criminal defendants. So we'd be asking that that also not be as heavily scrutinized as the state is requesting.
Well, the court is concerned by the prior history of arrest involving the same victim by this defendant. And it does find that it is adequate to set bond. It was $5,000.
5,000 for count one, yes, Your Honor.
And count two.
Count two, we're just asking for the standard 150.
Okay.
We also are asking for a DPS level 1 on count one.
And fine for me, level 1 again.
That is total lockout.
Bennett, where would he be living if he's released? Because he cannot stay with his mother.
I got other places. You have it on the place? Yes.
Okay.
I could find my friend's house, my aunt's house, my grandma's.
Judge, he has family and friends in the area that he could stay with.
Okay. And level 2 is what?
Level 2, they are allowed to only leave the home if it's pre-approved by their house arrest officer. Typically for work only.
Okay, I'm gonna have the GPS bracelet level 2.
Your Honor, is that plus bond or alternate?
I'm sorry, corrections.
Is that plus bond or alternate?
That's plus the bond.
GPS level 2.
There's also a stay away order going to be entered. You have no contact with Odalis Martinez, which I believe from the arrest affidavit is your mother. So till this case is resolved, you have to find somewhere else to live and you have to stay away from her. If you want to retrieve your clothing, personal belongings, you have to do so with the escort of a police officer in the next 48 hours.
Your Honor, do the house arrest applies to count 2 as well?
No, this is just on the battery. There's a standard bond of 150 on count 2.
Thank you.
So, Jonathan?
The record reflect that liaison has caffeinated the court. And only the court. The clerk objects. The court notes the clerk's objection. Jonathan Antonio Silva.
Sir.
Mr. Silva, you're charged with battery. The court will review the arrest affidavit. The court finds probable cause for the charge of battery.
Judge, I would be challenging that.
Okay, what is your challenge?
The A form states that Mr. Silva was trying to leave the home and was being prevented from doing so by his wife. It doesn't state that he was trying to drive, which was her ostensible reason for trying to keep him inside the house. To me, that states a prima facie case of false imprisonment, and he was merely acting in self-defense.
Okay.
Your Honor, the A form does not indicate how the victim was trying to prevent him from leaving the home. It could have been something that's simply standing in front of him, in which case the defendant could have walked around him. But the A form does state that the defendant aggressively pushed and shoved, causing injury to her right arm and hand. So it is our position that that is enough to find probable cause for the battery.
Well, what's your position on,
We're just asking for the standard $1,000.
if the court does find probable cause? Well, let me hear from the defendant on, bond.
Your Honor, because Mr. Silva has no prior convictions, at least locally, we'd be requesting that he be released on his own recognizance. And he has no documented domestic violence history with this alleged victim.
Standard bond of $1,000, but also enter a stay away order in favor of the alleged victim, Rebecca Rosales. I'm not sure what the exact familial relationship is.
I believe it's his wife.
Okay. So you're gonna have to stay away from her until this case resolves. You're gonna have to find alternative living for the time being. You may return to the property for purposes of getting your clothing, tools of the trade, etc. But you have to be accompanied by a police officer. Case will be set before a domestic violence court judge, and the stay away order will remain in place until that judge decides what to do with it. Yes. Thank you.
If you want to remain in, if there's like a hurricane or anything, you check back and come back in custody while the emergency that's going on, or get to the back. If we go back.
Hopefully we don't have any hurricanes in March.
It's beautiful now.
This is when I have my first hurricane.
Oh, don't say that.
No, from Nebraska.
Someone who wasn't living here in 1992, Hurricane Amy. You don't want to say that.
She loves weather though. She can tell you all about
Tornado
tornadoes.
alleys, so it's just a wet tornado. Yeah.
A wet tornado is crazy.
Yeah.
Misdemeanor calendar.
Good morning, Judge Green. This is Joanne Hennessy. I just want to let you know I'm here for the jail arraignment calendar for the city of Miami Beach.
Did you really bring this for me? Thank you. That's very thoughtful. Okay. Good choice.
Yeah. I was trying to get them out. But yeah, go to the finish. That's it.
All right, Mr. Public Defender, I didn't catch your name.
Assistant Public Defender Teo Desake for the record.
How do you spell your last name?
DE space SA DeSake.
DeSake?
Yes.
Okay, good morning.
Good morning.
Are you felony prosecutors or county court?
We are both misdemeanor domestic violence.
Are you assigned to a specific judge?
We have both been in front of Judge Garcia Villalobos, shadow switching on Monday, so Judge Garcia.
Now, Mr. DeSake, are you a felony public defender?
No, Judge. I began in August. I am still in county.
County
Misdemeanors.
Misdemeanors?
Yes.
Yeah, I'm so sorry, but you should. You told me to know how I forgot it. That's right. Yeah.
I got it. Yeah.
Thank you. Thank you.
The best is.
Yeah, that's fine. Let me see if something is over here. Okay. Because I know corrections was trying to contact them earlier and didn't answer. Corrections, you will get in contact with you, Lena?
Corrections?
Is the misdemeanor clerk in there, Your Honor?
Yeah. Did you ever get in contact with them?
No, we never got in contact with the misdemeanor clerk, and we have an add-on. We also just called, and we didn't get an answer either.
Shout.
It looks like you've got to stay with us for the rest of the day.
I don't know, Mr. Chair, I'm sorry.
You don't have to leave every day.
Batteries are misdemeanors.
I do TV every day. Let me call, let me see if I can contact the supervisor. Hold on. They're calling. They're calling. Courtney. Hello. Yes. Yes. No, I'm going to talk to supervisor now. See if I can get contact with him, okay? Okay. You're welcome.
Wait for the clerk. Is that it?
Yeah.
I'm ahead of schedule. right? Let's go. No. No. All right, let's keep it moving.
I called the supervisor, she's calling up there now, to try to get in contact with somebody, okay, Judge?
All right,
Have a good day.
you too. God bless you.
Thank you.
It's already so huge.
Good morning.
It is. Let's do it.
They're on the phone. All right, for the rest.
Judge, may I briefly step out to use the restroom?
Sure.
Thank you.
I think the park is still getting set up, so.
Okay.
Let's give the PD and the state a bathroom break, so.
Homeless calendar, if the person doesn't have a mailing address,
Okay,
we can set it on there as oral notice.
we just tell them it's this date and
Yeah,
it's up to them to show up.
Right, and then we write it on the paper, so then we know. Question on how to fill out.
You can see this one.
Yeah, the
was here
reset.
yesterday.
Yeah, resets on the bottom. On the blue sheet. Fire's right here. Yeah.
And pick a bathroom. Okay, it looks like the public defender is back. Are we ready to begin?
Yes, Your Honor.
Correction, you ready?
Yes, Your Honor, ready.
Yes, unless otherwise noted. So the first case is Marie Roseme. Good morning, Miss Roseme. Miss Roseme has 3 cases this morning. First one is M25-4603. Charge is aggressive handgun obstructing. This was recent from yesterday. State.
Your Honor, the state would be requesting a $250 bond for each of the 3 counts charged.
Why is that?
I believe, Your Honor, the standard bond for trespassing after warning is $250. So
The first one is panhandling.
for panhandling, Your Honor, we would be willing to do a $100 bond.
I'm just going to say, yesterday your colleagues no process panhandling.
They no cross panhandling.
They did.
I'm sorry, Your Honor.
I'm not telling you what to do. I'm just reporting on the facts.
Your Honor, we would be willing to ROR on the panhandling case, but not to no cross it outright. And then for the other 2 counts, we do a $250 bond.
Okay. And then the other case is there's a bench warrant on a trespass after warning. This is at 10 Doctor on the River, 340. And then the third case is a bench warrant of $150 with trespass after warning at 101 West Flagler Street. So let me hear from the defendant on these cases.
Judge, for the first case, panhandling, I'd be arguing that there's no probable cause. The A4 merely alleges that Miss Roseme was sleeping on the sidewalk, not engaging in panhandling in an aggressive manner. For the other 2, I don't have a probable cause argument, but I would be requesting that you release Miss Roseme on her own recognizance. She has no prior convictions. Here, in her priors, she has 1 withhold and 2 no process. These are non-violent offenses. She does not pose a threat of harm to the community. And if she is ROR'd, we'd be requesting that she be given a date certain on the homeless calendar.
Okay, so on the first case, the panhandling aggressive, the court agrees with the defendant. There is no PC.
She'll be requesting that should be released outright.
Correct. She'll be released outright. The next 2 cases, the court's only concern is that she was ROR'd before, but then she didn't appear for court.
Yes, Judge. If I may respond, I'm not sure if she was given a date certain on the homeless calendar. That's a specific courtroom in the Gerstein building dedicated to unhoused individuals who can receive oral notice. Because Ms. Roseme is unhoused, that might be an explanation for the failure to appear because she doesn't have anywhere to receive notice in the mail.
Okay, the court agrees. We're going to give her an ROR. And this is case number M24-21691. And this will be set for the homeless calendar, April 9th at 9 o'clock, courtroom 6-7.
Thank you, Judge.
And I'm going to do the same with the other case. Let me just write this in. But I'm going to enter a stay away order for Flagler on the river. Ma'am, you have to stay away from the property at 340 West Flagler Street. Again, April 9th, 2025 at 9 a.m.
I remember there was another one where I put the waiver, so that when you have insurance going to which are granted.
Just for the record, is that an ROR as well for the case ending in 4603?
Case was released outright.
That one, Teo. Yes, that's after warning for our arrest affidavit.
No. The 254603 is Panhandle.
No, that 2.6.
Yeah, I don't have it for the trespassing case, but
4603.
okay.
Good morning. You're Abigail Abraham, right?
No, Abraham is a bond out.
She bonded out already? Okay. Thank you.
Abigail Robin Abraham.
It's the bond out, Your Honor.
Okay. Pieta McCollum Robinson. This is a warrant case, is that right?
Your Honor, Ms. Robinson has a new felony. She will be on your bond hearing calendar next.
She'll be here later for the felony.
That's correct.
So here it's just for the misdemeanors.
Yes, that's for the bench warrant.
She should be here, Your Honor, for petty theft and resisting officer without violence to person charges.
Well, I see an arrest affidavit for the new charges, I guess, but I don't see the warrant case. Where's that?
Well, there are 2 counts. 2 counts.
It's one case with 2 counts, Your Honor.
That's correct, but I believe those 2 counts are the petty theft and resisting without violence. I don't see the bench warrant either.
Yeah, clerk, can you show me where the bench warrant case is?
That is
On the jail card, the case I'm showing is for a bench warrant B25001859.
yeah, we can't find the files. We have a read out, but both counts are for bench warrant. A total of 300.
Where do I sign for that? There?
Yes, there you're right.
Okay, so I'll set bond at the bench warrant amount.
150 each count.
But there's 2 counts, right?
Yes.
Anything else in this case?
Judge, I would be making a probable cause argument for the resisting an officer without violence. The A form merely alleges that Ms. Robinson looked back as to the officer as he activated his lights and sirens. That's not conclusive evidence that she had a knowledge that he intended to detain her or that he was under the legal duty to arrest her. So for that reason, we're arguing that there's not probable cause for the RWOF.
Well, those are the new charges, right? Which we would address at the felony bond hearing. Correct? If she has a felony with attended misdemeanor charges. I addressed all of them at once, right?
Yes, Your Honor.
So I'm only addressing the bench warrant case right now.
Understood. My apologies.
Let me just clarify, that's correct with the clerk, right?
Yes, this is separate recordings for misdemeanor traffic.
But the
It's only the misdemeanor bench.
The recent arrests and charges include a felony possession of cocaine with 3 misdemeanors. That will be addressed later today.
Yes,
Understood.
Your Honor.
I'll hear your argument later today, counsel.
Okay. Come on, Ms. Ross.
I'll pass that on to the felony attorney.
Okay. Looking at their stay away order, she cannot go to the Family Dollar store at 904 West Palm Drive, Florida City. Genesia Patterson. Ms. Patterson, you're charged with trespass after warning at Aventura Mall, Paxson.
Your Honor, in this case, the state would request a $500 bond.
Okay, defense.
Your Honor, we'd be requesting that Ms. Patterson be ROR'd or alternatively granted pretrial services. She does have a place to live.
Does she have any other open cases at this time?
She has no other open cases, Your Honor. She does have 2 previous convictions for trespassing on property after being warned.
Okay, I'll find probable cause. Will corrections take her for pretrial services?
Usually if they've been here at least 1 year as a resident or and no battery case.
1699 Northwest 27th Court.
I'm going to do pretrial release with an alternate bond of $500.
Thank you, Judge.
There's also a stay away order for yes, this is the Aventura Mall 1456.
And Judge, we would be objecting to the stay away order as overly broad. If it could be limited to the Paxson store rather than the entire mall. It's a very big mall.
I agree.
The state would be willing to.
Okay.
The Paxson store.
It'll be limited to Paxson. Is it Sons or Sun?
Paxson.
You said 22nd Court?
27th.
7th. Okay. Is there an apartment number?
No, it's a house.
Okay. All right. Bond and pretrial services.
Ken Naomi Zamora.
When
You have to pay the bond or go to pretrial services. I'll be in touch with you.
what is pretrial service?
It's an alternative to bond.
I don't understand what you're saying.
I can't address it right now, unfortunately, because we have to go to the next person, but someone will be in touch with you
When
about
I
it.
get out of jail.
Whenever pretrial services talk to you,
Yes.
you gotta wait for them to come talk to you, your unit, you're gonna get them the information, and then they'll be. Right now, we gotta move
So
on
how
to the
long
next.
does that take?
Depending on how busy they are. A week?
Okay.
No, sometime today or tomorrow.
Good morning, Ms. Zamaran. Zamora. You're charged with the petty theft.
Just a minute.
Uh,
Your Honor, we'll be requesting the Spanish interpreter, please.
okay, I'll wait.
Interpreter present. Interpreter present, Judge.
Would you please advise the defendant she's charged with a petty theft? I'm trying to find the location.
It was a Walmart, Your Honor.
At the Doral Walmart.
Señora, ¿a usted se le acusa de hurto de menor cuantía en el Walmart que queda en Doral?
Find that there's probable cause.
Hallo que sí existe motivo fundado.
Date.
The
No,
state-
no priors.
No priors, Your Honor. The state would be willing to do pretrial release, pretrial services with an alternate bond of $150.
Su señoría, la fiscalía está dispuesta a darle servicios previo al juicio, que la dejen salir bajo servicios previo al juicio con fianza alterna de $150, por lo que no tiene antecedentes.
Okay, ma'am, you're gonna be released to pretrial services, assuming they can verify your address. Alternately, there's a bond of $150.
Señora, entonces I'm sorry, Judge, go ahead.
And I'm entering a stay away order from the Doral Walmart.
Señora, entonces la van a dejar salir de la cárcel bajo el servicio previo al juicio siempre y cuando ellos puedan verificar su dirección. Como fianza alterna tiene una fianza de $150 y también tiene una orden de alejamiento, no puede acercarse al Walmart que queda en Doral.
Es todo.
Zamora Glenda Torres. You're here on a bench warrant that was issued on a case where the charge is, I'm trying to find it.
The charges, Your Honor, are resisting officer without violence, petty theft, and criminal mischief. The criminal mischief is $0 to $200. The petty theft charge is more than 100, but less than $750.
Let me see the history of this case. Guess this was separate trial, or there's notes in here indicating that a court offer was, so I guess it was set for trial at some point. Motion to set aside bench warrant denied. Defendant failed to appear. State certified jail. Defendant pled not guilty. Yeah, so how many charges are there?
There are 3, Your Honor.
Of the 5,000.
What's the bond of count 1 standard?
No.
I believe because of the bench warrant, the bond is now 5,000, but I was gonna look up the original bond for this.
I think it's 5. Yeah.
Oh, I see what the bench, I'm gonna just set it what the bond, the bench warrant was. Count 1, 3,000. Count 2, 1,000. And count 3, 1,000. Ma'am, the reason your bond is so high on these cases is because you have a history of failing to appear for court.
Your Honor, if I may.
You may, but you know, there was a motion to set aside the bench warrant you didn't show, and it was denied.
Yes, unfortunately, Ms. Torres is currently unhoused, which makes it much more difficult to appear in court. I'm not asking to ROR, but I would be asking that you set the bond at the standard amount in light of her being unhoused.
Recognizes her situation and sympathetic, but unfortunately I have to set a bond that would guarantee her appearance in court, and she has not demonstrated a history of appearing, so I'm going to leave the bond set as it is.
Understood. Sorry.
There's already a stay away order in the case.
Okay.
That was entered by the fire judge.
Morning. English or Spanish? English, okay.
Jayla Hill? Ms. Hill is here on a bench warrant for a misdemeanor case.
Your Honor, she bonded out.
Oh, she did?
Yes, Jayla Hill bonded out, correct?
Thank you.
Sorry?
I do with the stay away order when she bonds out.
Can't enforce it.
I'm assuming if she did bond out too, that then one may have already been entered, but
No, there's no stay order.
So I can't enter it.
You can't enter it without the defendant present.
Doesn't have notice and an opportunity to be heard, right?
Correct.
Due process. Okay, traffic. Amanda Marie Baker. Search with DWLS. There was a $10,000 bench warrant for Judge Correa. This was set for a jail trial on March 4th. I'm out of space here. Where do I write? On bottom?
Right at the bottom, you were here. Are you resetting?
Well, no, she's here. She refused yesterday.
Okay, refuses to, and she's here. What would you like to?
I'm gonna set the bond as
Right here.
the bench warrant amount.
I'm not here. No, it's fine.
Okay,
One second.
I'm setting the bond at $10,000 because she did not appear.
Your Honor, I don't see a history of failure to appear for Ms. Baker. We'd be requesting that the bench warrant amount be set at the standard.
What's the state's position?
the state would just ask for the original bench warrant amount to be maintained, the $10,000. Especially given that the defendant was supposed to appear in court earlier this month for trial.
And she was taken into custody on this bench warrant, so she is already being punished for it.
What is, this is a DWLS, I assume? So right?
I don't have any of the case's information before me other than the bench warrant, Your Honor, but it appears to be a traffic case.
Did she have any criminal history, State?
Yes, Your Honor.
I don't think I have that for her.
She has, is that okay? Oh, okay.
Thank you. Defense, she does have a fairly extensive criminal history, including her last conviction I see is in December on 2 cases for cocaine possession. She got conviction from the CTS. What would you recommend as the bond in this case?
Your Honor, I would be ideally requesting an ROR, and that should be set on the homeless calendar. I've just been informed by Ms. Baker that she's currently unhoused, and that explains her failure to appear. It was not willful. She says that she did not receive any notice, which I do see happen very frequently because I'm in the jails division in the Richard Gerstein building. So if the ROR is denied, we'd be requesting that she be set at a $500 bond.
Your Honor.
Cocaine possession is not a crime of violence, and that's the defense's position.
Your Honor, if the public defender's office was appointed to her for her previous case, even though she would not have received notice herself, I assume her attorney could have kept her informed.
I don't know if that's the case, though. It was. But they may have lost contact with her. You know, $10,000 does seem excessive for a driver's license charge. I am going to set the bond at $500.
Thank you, Judge. $500.
No, to be
Do you have
honest,
that?
they don't charge.
you, corrections.
Jacqueline Rose, Patterson.
Yes. Ms. Patterson is a VFOX, Your Honor.
It's a what?
Offender of special concern.
Okay. It would be helpful, corrections, if you do not use acronyms for the court, but thank you anyway. I have a charge of no valid driver's license. Driving while license suspended.
Your Honor.
That's just, these are new offenses and not a bench warrant, correct?
Correct.
That's correct, Your Honor.
Okay.
Because the defendant is a violent felony offender of special concern, we would be moving to hold the defendant no bond.
On traffic offenses?
Exactly.
Yes, just because she was on probation, I believe, Your Honor, for a felon. So even though these cases are traffic cases, she's on probation for a child abuse charge.
We don't here, we do like if you do a felony hold. So that gives the case on.
Your Honor, we would request a felony hold in that.
The facts that were you able to hear what the state was saying?
Yes, Your Honor. It seems like quite the ask for to hold her no bond. That is unconstitutional.
No, but they were, I think, asking for a felony bond hold because she's on a felony probation case.
I believe that would have to be addressed at the felony level when her case is before the court. But right now, for the DWLS no valid driver's license, I believe that standard bond would be appropriate.
Your Honor, the felony hold is very much something that you can enter into. It just means that you until the felony judge has a chance to address her bond in that case.
Could I please get a felony case number?
Do you have that case number?
Yes, the felony case number is F21 20255.
Could you write that up?
Yes. F21
202
202. And the charge on that is child abuse?
That's correct. And it is child abuse, but it is no harm.
And it's felony probation?
That's correct.
Felony hold.
All right, I am going to put a hold on the probation case and set standards on this case, which is
150.
150 for each count. So a total of 300. Do I have to indicate that's a charge?
Well, just write just 500 there. You just write 500.
Okay. No, 300.
Oh, excuse me. 150 on each one. 150 on each one.
Times 2.
Well, you have the other two.
Oh,
the other two. Here, this one here.
No.
Where's the other ticket? Oh, here. There, $150.
So 150 for the no valid driver's license, 150 for DWLS. Probable cause. Carlos Antonio Bonnet.
One moment, Your Honor.
Your Honor?
Yes.
I'm sorry, can we readdress the case that we just talked about?
Yes.
The case number that the state provided was F21 020255.
I wrote it down, so I don't have it in front of me.
20255.
That's correct.
Yes.
I have put on CJIS indicating that it was no prost.
Hold on, let me call her back.
Jacqueline, come back.
And there was an order terminating pretrial release conditions in 2022.
It's in what?
She finished it, and it was no problem.
She got pretrial intervention.
Correct.
That's correct, Your Honor. It's the state's mistake. We believe she was still on probation for that case or completing pretrial intervention.
Just discharge that felony hold corrections.
That's an egregious mistake.
Judge.
So she would, in that case, she would also not be a VFOS, just so corrections is aware. She wouldn't have that status if she's not on
And
probation.
it was corrections that announced that.
That's correct.
Okay, so corrections and the state, you are both wrong in making a grievous mistake on this woman's case, okay? I put a felony hold on a case that was null prost. She's not a violent felony offender. All right, she gets it. You want to readdress her status?
Your Honor, she's a violent felony offender because of her past.
Okay.
And every time she comes to court, it will be on the jail card.
Felony prior.
Every time she comes to court, a violent felony offender will print on the jail card.
What is her past? Can I see her criminal history, please?
Yes.
They only have child abuse, no harm, PTI. I don't know how corrections is classifying her as a violent felony offender. Could someone please explain it to me? Oh, no explanation. Does she qualify for pretrial release?
Can you get, do you have a place to live? Yes, Your Honor, Miss Pajaron does have a place to live. So we'd be requesting pretrial services as an alternative. Well, we actually would be requesting an ROR at this point because this was the purported case that made her a violent offender and it was no prost.
Yeah, PD, I'm suggesting you do something with corrections to see that that's removed from her card.
Yes, I'll look into that, Your Honor.
It's very unfortunate that she would be tagged with that.
No corrections?
I'm gonna order pretrial services,
Print it out.
an alternate bond of 150 on each case.
Thank you.
Yes. Please be more careful.
She has an AC number, that's why it's printed out like that.
You got pretrial services as an alternative, they'll be in touch with you.
Okay, so.
Okay, you have 150, and the alternative is pretrial services, which can get you home, okay?
Okay.
Right.
Thank you.
Good luck, ma'am.
Carlos Antonio Bonnet.
Mr. Lane refused, Your Honor, reset for tomorrow.
I'm sorry, who refused? Mr. Bonnet?
And Marlene, Your Honor.
Did Carlos Antonio Bonnet refuse?
1 second, Your Honor.
What page for mine is number 39.
Your Honor, are you kind of bonded out of turn?
That was my next case.
No, the next case should be Lane.
This was,
Okay, yes. Yeah.
okay. All right. Mr. Antrell Lane.
He refused, reset for tomorrow.
Okay, reset. Now, Mr. Bonnet's case, all right?
No, I think they're gonna go here on this.
The next defendant, Your Honor, should be Daniels Jonathan.
Okay. Jonathan,
Refused, reset for tomorrow.
he refused?
Yes, reset for tomorrow.
Okay, reset tomorrow. defense, this is a second refusal. Is there anything you want to say?
Your Honor, can we accept appointment in absentia?
Okay, he was already appointed on this case.
Are they waiting?
Do you want to waive his presence for purposes of the probable cause bond hearing?
Yes, Your Honor.
All right, let me look at the arrest affidavit. Charges indecent exposure. Occurring at the pretrial detention center. The court finds probable cause.
No PC argument from the defense.
What's the standard bond on this?
Daniels, it's to be said, Judge, there's no standard.
For indecent exposure, you know, what's the state's recommendation?
They would ask for a $1,500 bond.
He's in custody on other charges, I assume. It's felonies?
Yes, Your Honor.
Your Honor, because this is a first degree misdemeanor, we'd be asking for a $500 bond.
Well, being that he's in custody on other charges, and this occurred in the correctional facility, it's going to be $1,500. Terry Maurice McCrae?
Yes, Your Honor.
He refused, Your Honor, reset for tomorrow.
Okay, reset. This is the second reset.
No, yesterday he was moved to pretrial detention.
Okay, got it.
Your Honor, the defense can waive his presence.
Your Honor, just for the record, is Mr. McCrae, he's being reset for bonds another day?
No, they're waiving his presence.
Okay.
So looks like he has two cases. Petty theft with the prior conviction. The first case is case number B254597, the Brand Smart store. Finds probable cause. It's the state's position on a bond.
Your Honor, the state would be requesting.
This was just charged as a straight petty theft. Second degree.
That's correct, Your Honor. The defendant does have significant priors, so we would be requesting a $500 bond for this specific petty theft charge.
Defense.
Because this is a second degree misdemeanor, the defense is requesting a $150 bond.
Okay, yeah. I'm going to set it at 150 on this case. So we'll now look at the other case. And his presence has been waived by counsel. This is petty theft with a previous conviction.
That's correct, Your Honor.
At the Walgreens store.
No. We're still addressing someone else.
I'm going to find probable cause. What do you want? What's the bond the state's asking for on this one with the prior conviction?
Because this one is with a prior conviction, the state would be asking for double the previous bond, so $300.
All right, the court will set the bond at $300.
No objection from the defense.
Neil Hunter,
Morning.
Mr. Hunter is charged with defrauding an innkeeper. Court will review the affidavit.
I'm on vacation.
Court finds probable cause. State.
The state would request pretrial services with an alternate bond of $150. This is, I believe, the first offense for this defendant.
Your Honor, I've just been informed that Mr. Hunter does have an ICE hold, and we'd be requesting that he be granted a dollar bond. He does not live in this country. He has no local priors. And his cards have been blocked, so he's not able to pay the $150 bond.
Well, he gave a local address of 1200 Brickell Bay Drive. He doesn't
Yeah,
live.
Judge, that's his Airbnb.
Oh,
Mr. Hunter lives in Dubai.
so he wouldn't qualify for pretrial release. So you were seeking what defense?
Sorry, Your Honor?
Instead of pretrial release, you were for what?
We're asking for a dollar bond in light of Mr. Hunter's ICE hold.
Your Honor, if his cards have been frozen, he can't pay the dollar bond or the $150 bond. Because of the offense, we do believe $150 is appropriate. If the ICE hold is lifted and he's able to pay it, he can be released if he pays that.
I'm gonna set bond at $150. Because the allegation is he ran up a $500 tab at Moxie's and walked away from it. If he can run up a $500 tab, perhaps he can pay the bond of $150. Is there a stay away order requested? Mr. Hunter, you're to stay away from Moxie's at 900. Is it 400 or 900? Moxie's.
Your Honor, it should be 9. This apologizes for the unclear 4 or 9.
Okay.
All he considers is the arrest form. For probable cause, he only considers the arrest form.
I'm going to be detained for this office.
Yes, and we'll be in touch with you about that.
So what do I do now? Because I need to make
No,
sure
wait.
I've got no
Yeah.
access to
Wait,
buy numbers.
just wait for the public defenders to get in touch with you. I'm sorry.
Antonio Thornton.
Okay, come on,
The attorney is a valid felony offender, special concern.
I'm sorry, I didn't hear the corrections.
Morning, Mr. Thornton. Can you make sure it's finished?
Mr. Thornton is a valid felony offender, special concern.
Okay.
However, for Mr. Thornton's case, we would request a $500 bond and a felony hold.
Does he have an open felony case right now?
Your Honor,
He's on probation.
if he is a veteran, that should move. He's on probation. But
I see, case number F23-23145A, strong arm robbery convicted, special condition probation. That was August last year.
Your Honor, before we address the bond, the defense has a probable cause argument.
Okay. I mean, he's charged. I'm sorry, jumped ahead. Mr. Thornton, you're charged with resisting an officer without violence. He was asked to leave the property. He refused to leave after being ordered multiple times and was ultimately detained for obstruction. He appeared heavily intoxicated. And then he was arrested. All right, let me hear from the defense.
Yes, Your Honor. So to charge a defendant with resisting an officer without violence, the state needs to prove that the officer was engaged in the lawful execution of a legal duty, and then during that lawful execution, which occurs at detainment or arrest, the defendant resisted. Here in the A form, what's being alleged is that the officers were investigating an assault. It doesn't allege that the assault was committed by Mr. Thornton or that he was a suspect for that assault. And then he was detained for obstruction. and appeared heavily intoxicated. It doesn't say that at any point he resisted arrest or that he resisted the arrest for obstruction. What's being alleged is that the officers arrested him for remaining at the scene and then took him into custody right after that. There was no resisting happening at the moment of arrest or detainment. That is not being alleged on the A form.
State?
Your Honor, resisting without violence is not just limited to resisting arrest specifically. It can also be resisting a lawful order. In this case, the police were trying to clear the scene of an investigation. They asked the defendant to leave repeatedly per the A form, and he refused to do so. So I believe there is probable cause within the four corners of this arrest affidavit for resisting without violence.
Your Honor, there's a litany of case law that details that the defendant has to be at the very minimum detained, and that's not what's being alleged here.
What's alleged is that they were conducting an investigation for assault and he refused to leave after being ordered. At the very least, it appears to the court there's probable cause for disorderly intoxication. But
I would agree with the court on that, but not for resisting an officer without violence.
all right, I'm gonna find probable cause for disorderly intoxication, which is first or second.
Your Honor, I don't know, but I could confirm.
A second.
It's a second degree misdemeanor, Your Honor.
Okay, so the bond on that would be 150.
Yes,
Now, he does have a felony probation case. I'm gonna put a felony hold on case number F2323145A. You'll have to go before the felony court judge on that case, sir.
I'm sorry, Judge, so you're imposing a felony hold?
Yes, because he's on felony probation for strong arm robbery.
Understood.
Danny Perea.
Sir.
Sir, you're charged with battery. Court finds probable cause. State want to address the bond.
This is your permanent address. Okay. Understood. Unfortunately, we can only argue what's written here. Okay. I can't bring facts outside of the A-form.
You have the progress on Mr. Perea. Herrera. Looks like he has a prior null process.
You've always lived in Miami.
Processes that are, but he has a drug paraphernalia case pending. What's the state's position on bond in this case?
Your Honor, in this case,
I
given-
found probable cause.
given the pending charge, we would request a misdemeanor hold so that bond can be addressed in the misdemeanor case, and we would also be requesting $1,000 bond for the battery.
Well, I'm not going to hold it on the other case, but I'll set the bond at $1,000 in this case.
Your Honor, the defense would be requesting that Mr. Torreira be ROR'd. He's lived in Miami his entire life and has, for the most part, stayed out of trouble. He only has a cannabis possession, retail theft that were both null prost, one in 2011, the other in 2016. The drug paraphernalia charge is the criminalization of poverty, essentially. And the battery is the first one on his record. In light of him, for the vast majority of his life, living here, staying out of trouble, and picking up this charge now, we think an ROR is appropriate. Alternatively, we'd be requesting a $500 bond with the alternative of pretrial services.
Clerk, could you tell me what's happening with the drug paraphernalia case? Here. He has a local address. Would he qualify for pretrial services?
He does, Your Honor.
Okay, he was our award on the other case. I'll release him to pretrial services with an alternate bond of $1,000.
Thank you, Judge. The pretrial services people.
Now, there's a stay away order. I'm not sure who the alleged victim is, but the initials are JC. He's to have no contact with the alleged victim in this case.
They'll be in touch with you. It's an alternative to bond. Okay. So what else? Properly.
Carlos Briones Lofredo.
Yes, he only speaks Spanish.
Okay.
Spanish interpreter present.
Sir, you're charged with possession of drug paraphernalia.
Señora, ¿usted se le acusa de tenencia de parafernalia para el uso de drogas?
Court finds probable cause.
Hallo que sí existe motivo fundado.
No priors.
There are priors. No priors, Your Honor. I apologize.
No tiene antecedentes.
Would he qualify for pretrial services?
¿Calificaría él para servicios previo al juicio?
Yes, Judge, but we would be requesting an ROR for Mr. Briones. He has no priors. This is a nonviolent offense.
Sí, su señoría, pero estaríamos solicitando libertad bajo palabra para el señor Briones. Esto no es un delito violento y no tiene antecedentes.
Your Honor,
Any objection?
the state would ask for pretrial services all bond 150, Your Honor.
Su señoría, la fiscalía estaría solicitando el programa de servicios previo al juicio con fianza alterna de $150.
Pretrial services with an alternate bond of 150.
Entonces se le da servicios previo al juicio, el programa, con una fianza alterna de $150.
Pero si no, no tengo que me la pague.
I don't have anyone to pay for it.
It's okay, Madam Interpreter. I explained to him. Thank you.
Quisiera para saber.
Vante a llamar, ¿ok?
¿Ah?
Ya vante a llamar.
¿Cómo? ¿Me venga a llamar?
Jeremy Chancellor.
Good morning.
Sir, you're charged with battery, petty theft. They're alleged that you stole a cinnamon roll from Aubon's Han. But then dropped the roll on the floor outside the establishment and threw rocks at the alleged victim and was taken into custody. I find probable cause. State, what is your position on bond?
Your Honor, the defendant in this case does have priors. One of those priors is a recent conviction in 2018 for battery of an elderly person. Because of that, for the battery count, we'd be requesting a $2,000 bond, and for the petty theft count, we'd request the standard bond, $150.
Defendant, defense counsel?
The defense would be requesting the standard bond.
1,150?
Yes, Judge.
Okay. The court will set the standard bond. Count one, $1,000. 150.
We'd also be requesting pretrial services as an alternative. Mr. Dantzler does have a stable address.
Court is not gonna record as a pretrial. But I am entering a stay away order from the Audubon Pond. 9, this is 91. Your 9s look like 4s.
I do my 4s open top, Your Honor.
Okay. 901 Northwest 7th Street.
Your bond is at $1,100. You have to pay 10%.
Have a great day, Your Honor.
Thank you.
I asked for.
Your Honor, this is Joanne Hennessy for the City of Miami Beach. I'm here for the Mr. Connery's hearing.
Be right with you. Kenneth Ryan Connery. Charged, sir, you're charged with violating the Miami Beach camping prohibited ordinance. It says that you were camping at I'm not sure what the location is.
Your Honor, it's 21st Street and the beach,
Is this public or private property?
public property, Your Honor.
The defense does have a probable cause argument.
Okay, let me hear from you.
Judge, Miami Beach Local Ordinance 70-45 clearly states that if a law enforcement officer or other authorized official encounters a person engaged in camping who volunteers that he or she has no home or other permanent shelter, he or she must be given an opportunity to enter a homeless shelter or similar facility if available. If no such facility is available, an arrest may not be made. So Mr. Connery, according to the A form, did claim that he didn't have a place to live. And at no point did the officers offer him shelter per the A form.
See the line where he says he told the officer he was banned from all the local shelters, describing in one incident where he had an argument with Camilla's house.
Absolutely, Judge. And in light of the ordinance's plain language, if no such facility is available, an arrest may not be made. Then there's no probable cause for this charge here.
Your Honor, I would argue that we don't know that he state that he's banned from them does not make them unavailable. They're just not available to him. That is not, if you can't make yourself unwelcome in all the shelters and then state that they're not available.
Where does it say the officer offered him shelter? I don't see that.
And Your Honor,
no probable cause, he'll be released outright.
Your Honor, I apologize. When a defendant is released outright, are they given a date certain on the homeless calendar or no?
No. I don't think so.
State would stipulate to putting a date on the homeless calendar for this case.
You have to make him ROR.
In that case, when we're not going to be requesting a date certain, Your Honor, he's entitled to be released outright.
Yes, so that's what I'm doing.
Yes, thank you, Judge.
Jonathan Jose Colon.
Hello, yes.
Good morning, sir. You're charged with disorderly conduct and resisting an officer without violence. This occurred where? Let's see. A park in Doral. Court does find probable cause. This defendant wants to make an argument.
Yes, Judge. As to the disorderly conduct, it says that he was shouting profanities and making threats. There is case law indicating that acting merely boisterous and loud without immediately breaching the peace does not rise to the level of disorderly conduct. So we'd be arguing that there's no probable cause for the disorderly.
The court finds there is probable cause. What's the status on this felony case? State, do you know?
I can confirm, Your Honor,
Uh,
but it does appear to be.
It says set for report. I don't know. Does that mean the charges are pending or? It's kind of, sure. It is F24-16658.
Court on 17th for that. One is been notified on February 4th. We have a future hearing date of April 17th.
Your Honor, I apologize. Just briefly to add to the probable cause argument, Miller versus State, appellate first district, 667 Southern Second 325 does have a clear proposition that to sustain finding of disorderly conduct, there must be evidence of something more than loud or profane language or belligerent attitude. Here, the A form says that Mr. Cullen was being disruptive and belligerent in public. So
it also says that he failed to comply with the officer's requests, his verbal commands. He was putting his hands in his pockets. So
yes, Judge, that goes to the RWAV. But as for the disorderly conduct, I believe that there's no probable cause.
all right, well, the court does find probable cause, but he has I guess, more important for your client is he has a pending felony with multiple battery on Leo charges. And it's set for what?
April 17th.
But have they filed charges? Do you know?
Yeah.
Have they filed an information? Or is it?
Yes.
Okay. What's the state's position on bond since I found probable cause?
Your Honor, for this case, we would just ask for the standard bond for disorderly conduct, $150, and for resisting without violence, we would request $500 bond.
Okay, so count one would be 150,
as well as a felony hold, Your Honor.
count two, you said 500, right?
That's correct.
Felony hold case number F24 16658. I'm also looking at your stay away order. Does this say specific park? I mean, this is a little state. This is vague. I don't know.
Your Honor, the name of the park isn't on the arrest affidavit, but the best we can do is provide the address.
You're to stay away from 3005 Northwest 42nd Avenue in Doral, which, according to the arrest affidavit, is some type of park facility. Denny here.
You're good to go.
Sir, you're charged with resisting an officer without violence, drinking in public, and littering.
Yeah, Judge, I feel
No, please don't.
No, I want to talk to him. I feel like it's a big misunderstanding. You know what I'm saying? And
Sir,
I feel like
I would
resolved in court.
You have an attorney representing you, sir, so I think the best advice is to let him speak for you.
Oh.
If you want to talk to him, you can tell him what you want to say, but you want to make an argument? Counsel on probable cause?
Yes, Your Honor. Just one moment, please. Yes, Your Honor, I would argue that there's no probable cause for the resisting without violence. Merely moving around does not rise to the level of actively resisting. We would need to see something more akin to tensing up or actively resisting arrest in a way that impedes the officer from fulfilling his duty. So again, we're arguing that there's no probable cause for resisting without violence. The form doesn't allege in any way that that his duty was obstructed by Mr. Pierre.
Your Honor, the arrest form that says as after the officer already asked the defendant to walk to his car and put his hands behind his back, he began to move while he was trying to handcuff him, and he had to give him multiple commands to stop moving so that he could handcuff him. The state would ask you to find probable cause based on that. It's clear, even if it is not, even if it is choppy writing, that this made it more difficult for the officer to do his job.
All right, the court does find that there is probable cause. Obviously, sir, this is not your trial. The standard for a probable cause is much different. It's not proof beyond a reasonable doubt. Whether they can prove it at trial or not is a different question. But what's the state's position on bond?
Your Honor, I did just want to bring to your attention that there is an open felony case for this defendant. It's F-24-26152. So we would
let's have if the clerk could pull it up for me, please.
What name? Denny Pierre. I'm checking right now.
It's felony grand theft. An information file and a future date of March 27th.
Is it just a status report or?
Yes. So, Your Honor, the state would ask for a felony hold, and the state would also ask for the standard bond for each of the 3 counts.
Defendant, do you want to address that? Apparently, he has an arraignment coming up on a grand theft.
That's correct.
Yes, Judge, I do see that. We'd be requesting the standard bond in this case.
All right, I'm going to set the standard bond count 1, $500.
That's correct, Your Honor.
Count 2, $150.
Yes, Your Honor.
And I suppose littering is $500 as well.
Yes.
Your Honor, for the Florida litter law, we'd be requesting to match it with the alcohol drinking.
Well, I might consider that if he didn't have the open felony case. But I am not going to put a felony hold on the other case because we don't know what the state is going to do in that case. So.
Your bond is going to be $1,100. Take 10% of it. Yes. Do you have a place to live?
For like, can I get pretrial services?
Yes, Your Honor. Could Mr. Pierre also be granted pretrial services? He does have a stable address in North Miami.
Yeah, as I said, if he didn't have the pending felony charge, I would consider it. But unfortunately, since he does have that felony, I'm not going to consider it this time.
Understood.
Judge, did you give a bond for count 3?
$500.
Okay, come on, we got to go to the.
They're saying that it's you.
Come on, Manny.
I'm sorry, I can't address it right now.
Come on, Bourbon, John. Right here.
Morning.
Mr. Boudron, you're charged with trespass and resisting without violence for an incident that happened, at Jiffy's Food Market.
These people literally kidnapped me, bro.
Just 1 second, please.
All right, the court does find probable cause.
These people kidnapped me, bro.
Don't see any priors on the defendant. Does he qualify for pretrial services?
I believe so, Your Honor. He has a local address, so it would stipulate to pretrial services with the standard bond for each.
I have a place to live. These people kidnapped me.
We can address that later. I'm sorry. Yes, Your Honor, we would be requesting pretrial services, please.
Yes, pretrial services. The alternate bond is 500 on each count.
So what's gonna happen?
Also stay away, so he has to stay away from
Release
food market.
In touch with you about that.
You heard the stay away order? You have a stay away order.
Stay away for what? I didn't do anything.
Okay, come on, sir. Lubin,
So what's gonna happen to me?
you gotta wait till somebody comes out and comes forward.
Morning.
Levine Arcelia or Australia. Sir, you are charged with resisting an officer without violence for an incident that allegedly occurred.
Your Honor, he's also out on felony bond F25003469.
I see that. Thank you. Thank you, corrections.
You're welcome.
Your Honor, that does appear to be the defendant's only prior or open case. But we would still ask for a felony hold just for the purposes of allowing the state to address bond in that matter again. Or the court rather, and let the state decide what they want to ask for, but then we would ask for the standard bond for the count itself.
Well, let me first review for probable cause. The allegation is he gave a false name to the officer, is that correct? If I read it correctly.
That appears to be.
Any argument from the defense?
Yes, Judge. The only allegation for the basis of the RWAV here is that Mr. Arcelia gave the name of Lubin Arcelin. That is extremely similar to his name. This could have been a misunderstanding. The system tends to provide incorrect names. I see this on various occasions of defendants being given different names at no fault of their own. And just the striking similarity here begs to reason how this could be charged as resisting an officer. He did provide his name. Because of one letter, they're claiming that he resisted arrest. And to me, that does not rise to the level of resisting an officer to the point of impeding their duty. He did provide his name, and just this one letter could be a misunderstanding or an error on the police's part.
It is awfully close, State. It's off by like one letter, and maybe his handwriting wasn't very clear. So I agree. I find no probable cause to release him outright on this case.
So no hold on the felony case, correct, Your Honor?
Oh,
He wasn't arraigned yet, Your Honor, on the felony.
he has an arraignment pending.
That's correct, Your Honor. It's on March 12th.
Okay, you'll be released on this case, sir. Corrections called. Oh, Corrections needs to take a brief recess. I guess there's an emergency situation. Does anyone need to use the restroom? The court could take a short break.
On ice.
Go to the restroom. Thank you.
Thank you. I just know these are some of the stuff like yeah.
Hello? Hello, anybody in court? Yeah.
Which makes okay, yeah, I don't know, sitting there.
Yours is an old phone. Cord here is for you.
Corrections, do you need any more time or are you good to go?
Your Honor, we had a medical emergency. Few minutes, please.
You need a few more minutes?
Yes.
Okay, just let me know when you're ready.
Okay.
Oh, sorry.
The training that we get just says if you hear that phrase, ask them, but I just looked closer at the priors and see that was a close escape.
It was a PPI.
Yes.
Good morning, everybody. Is felonies next?
We still have about 8 pages of misdemeanors left.
Oh, I shall come back. Sorry to interrupt. Bye.
Oh, there's not a lockdown. Lockdowns, wait. No.
Can I plug it into that outlet over there?
It should reach.
No, I was just asking if I'm able to.
Oh, yeah, you should.
Okay.
Okay.
Your Honor, we can stop back.
Okay. All right, the next defendant is Leonard Brackenack.
Leonard? Yeah. The police takes the judge.
Morning, sir. You're charged with petty theft at the Target. The court finds there's probable cause. I don't see any priors.
There are no priors drawn until the state would request. There are no priors, and the state would request pretrial services, alternate bond $150.
He's from out of state.
He's from out of state.
Your Honor, the defense is requesting that Mr. Brackenack be ROR'd. He has no priors and does not have an address in Miami to qualify for pretrial services.
The state would stipulate the ROR.
All right, the state stipulates find probable cause. ROR the defendant.
RR, Your Honor?
Yes, ma'am.
May he be given a date certain on the homeless calendar?
Do they do that for petty theft?
If he has.
Actually, no, Your Honor, I apologize. We won't be requesting that.
No. Okay, but I'm gonna enter a stay away order for the Target at 10101 West Flagler Street.
You understand?
Yes, so you're ROR. You're released.
All right.
El Antonio Forti.
Bond out.
Whichever.
What would you prefer?
Bond out?
Literally.
That's a bond out, Your Honor.
Okay.
Wait.
Yeah.
Name is Rizzo.
Yeah.
Yes.
Sir, you're charged with trespass of an unoccupied structure or conveyance at 1683 Alton Road. Court finds probable cause. state what your position on bond.
The state would be asking for $150 bond, Your Honor.
Defense?
Your Honor, the defense requests that Mr. Rizzo be ROR'd. He is homeless. His only convictions are for smoking cannabis. He does have a prior trespass, which was a withhold of adjudication, so it's not a conviction. And his only two convictions were the local ordinance for smoking cannabis. We would be requesting that he be ROR'd. This is a nonviolent offense. And we'd also be requesting that he be given a date certain on the homeless calendar.
All right. I'm gonna ROR the defendant. You're to appear, sir, for the homeless calendar report on April 9th at 9 a.m. courtroom 6-7. Make sure you appear or you'll have a bench warrant issued for your arrest.
Where's the case number?
I'm also entering a stay away order for the property address 1683 Alton Road.
You have to show up on this.
Yeah. He's going over Zoom.
You can come on Zoom.
Yeah. Thank you.
Zachary Thomas Leahy.
Present.
Your Honor, for the defendant Rizzo, you ROR'd him?
The last defendant, yes, was an ROR report to homeless calendar.
Thank you.
Thank you. This is Mr. Leahy. He's charged with trespass also at 1683 Alton Road. Court finds probable cause. Defense?
Yes, Judge. Given that this is the same set of facts as the previous case, we're also requesting an ROR for Mr. Leahy. He is homeless. This was an unoccupied structure, a nonviolent crime. He doesn't pose a threat to the community. And because he doesn't have a place to receive mail, we'd be requesting a date certain for the homeless calendar.
He does have an open battery charge, which he has a hearing on. Well, what happened to this case? Do we know when the next hearing is on that case?
It's March 18th, Your Honor.
Is it pending disposition? Do we know?
I'm checking right now, Your Honor.
M24 27773.
My understanding is that this is an ongoing case, Judge, and there's no disposition in it. So, and he was ROR'd on it.
Okay.
The domestic violence case?
That's correct.
I am, because he has an open case when he picked this up, I am not going to ROR, but I'll set the standard bond of 150. Also a stay away order from the property, which is 1683 Alton Road. Anthony Ray Johnson.
Yes.
Good morning, Mr. Johnson. You're charged with trespass, also at the same location, 1683 Alton Road. Court finds probable cause. The A form also indicates he's homeless. State, you object to an ROR setting it for the homeless calendar?
The state would object to an R1 only because the defendant has a previous trespassing conviction. Also has previous convictions, a previous 2022 felony conviction for burglary. So for that reason, the state would object to an R1 and request $150 bond.
Where's the burglary conviction?
It's case number F22-15894, Your Honor.
It says consolidated with other case 15894.
Your Honor, the defense would request an ROR. Again, it's from the same set of facts, and it's not a crime of violence. It was an unoccupied structure, and Mr. Johnson is homeless, so we're requesting an ROR with the date certain on the homeless calendar.
I am going to grant the request for an ROR and order the defendant to report for the homeless calendar on April 9th at 9 a.m. Courtroom 6-7. Again, sir, if you don't report, there'll be a warrant issued for your arrest.
Okay.
All right. And a stay away order from the property at 1683 Alton Road, Miami Beach.
Okay. Thank you.
Morning.
Morning, Your Honor.
Sir, is this Juan Daniel Lopez?
Mr. Lopez is a bond out, Your Honor.
Mr. Lopez bonded out? Okay,
Yes, Your Honor.
thank you. Sydney Cotledge?
Yes, sir.
Good morning, sir. You're charged with resisting an officer without violence and disorderly conduct.
Yes, sir.
The court will take a look at the narrative to see if there's probable cause.
I knew he was following. Just 1 second, please. I have to read this.
Just 1 second, please. I told the defense.
Court does find probable cause.
Your Honor, the defense does have a probable cause argument.
Go ahead, sir.
As to the disorderly conduct, the facts alleged on the A form do not meet the elements required. The statute states that whoever commits such acts as are of a nature to corrupt the public morals or outrage the sense of public decency or affect the peace and quiet of persons who witness them, or engages in brawling or fighting, or engages in such conduct as to constitute a breach of the peace or disorderly conduct shall be guilty of a misdemeanor of second degree. The case law is clear. Merely to sustain finding of disorderly conduct, there must be evidence of something more than loud or profane language or belligerent attitude. That's a Florida case. And then again, Fleury v. State, Southern 3rd 330 from 2018. Mere boisterous behavior, even if it disrupts the operations of a business and draws onlookers' attention, is not by itself enough to sustain a disorderly conduct conviction. Right here, the A form says that the defendant started to cause a scene by screaming, cursing, disturbing the peace, which then caused a large crowd to gather. That doesn't rise to the level of disorderly conduct as required by the statute and reiterated by Florida case law. I'd be happy to analogize more cases if you'd like, but it's the defense's position that there's no probable cause for disorderly conduct here.
Right, and that case would involve a conviction, which is a much higher standard than probable cause. So the court finds probable cause for both charges. Does he qualify for pretrial services?
Yes, Your Honor. And then again, I would just direct your attention to one more case, Fields versus State, 24 Southern 3rd 646. The fact that a crowd has gathered to watch a defendant's behavior without more is insufficient to support disorderly conduct conviction. I understand that your concern is with probable cause. But it's the defense's position that the elements are not met here.
All right, so I'm gonna set pretrial services with the alternate bond of $500 on count 1 and $150 on count 2.
We have a history, me and this officer.
Unfortunately, we can only consider what's written in the A form. We can't argue anything outside of it. But you got pretrial services, okay?
And there's a stay away order from, what was the name of it? Was this Salvation Army or Goodwill? I can't.
It's a Goodwill, Your Honor.
At 441 Northeast 74th Street.
That business on purpose, Your Honor. I was at the
No,
business
please
on
don't
purpose.
discuss the facts of the case.
Council's 4 looks like 9 or vice versa.
Okay. Come on,
I'm good.
All right, the Bucks are.
So I read a blurb.
Your Honor, I apologize. Can I just give you one more case?
Go ahead, but go ahead.
Okay. McDonough versus Garcia, 11th Circuit case stemming from Florida. City residents' conduct after police officer informed him that he was banned from attending city council meeting, including flipping his middle finger, cursing, and allegedly grabbing his crotch in presence of peaceful onlookers, did not provide the officer with probable cause to arrest him for disorderly conduct under Florida law. And what's being alleged against Mr. Cotledge is much less than what's in that case. But I'll respect your decision either way.
All right. The court's ruling remains the same. As I was going to say, trivia. Apparently, the National Archives is looking for volunteers who can read cursive writing because it's a dying art. They don't teach cursive writing anymore in the schools. So now it's become like a foreign language to people that they need translators for the National Archives. Just found that interesting.
I will put in my application immediately.
Your Honor, I might need to get my 9s and 4s straight before I volunteer for something like that.
Thank you. You're probably dating yourself.
Hang on. Okay.
No.
Mr. Ortega will be needing the Spanish interpreter.
All right. Do we have the interpreter on Zoom? Okay, can she chime in, please, for Mr. Jose Ortega Gutierrez? Do we have her name? Do we know the interpreter's name? Is Miss Correa?
Yes, Judge, I'm sorry.
Good morning again. This is Mr. Jose Ortega Gutierrez. Please advise him he's charged with violating ordinance against drinking alcohol in front of the store.
Señor Ortega, usted tiene un caso por quebrantar una ordenanza de no beber bebidas alcohólicas frente a una tienda.
All right, the court finds probable cause.
Hallo que sí existe motivo fundado.
What's the state's position on bond?
¿Cuál es la posición de la fiscalía con respecto a fianza?
The defendant does have prior convictions for different alcohol-related offenses, including disorderly conduct, alcohol and curb drinking, and DUIs.
El acusado tiene antecedentes, otras condenas relacionadas con bebidas alcohólicas, tiene cargos que incluyen alteración del orden público, bebiendo, también beber en el andén, también cargos por manejar bajo los efectos.
We're asking for a slightly elevated bond of $250.
Estamos pidiendo una fianza levemente elevada de $250.
Defense counsel?
Defense would request that Mr. Ortega Gutierrez be released on his own recognizance. This is a nonviolent offense and activity that a lot of people partake in and are not arrested for. It will be his only hold. He has no other open cases, and because he is homeless, he does not have the ability to pay that amount. It's going to be the only thing holding him in jail, a beer can. So we'd be that he be ROR'd and given a date certain on the homeless calendar.
La defensa solicita libertad bajo palabra. Él no tiene ningún otro caso abierto que lo esté deteniendo. Este es un caso que no es violento. Muchas personas por esas actividades no son arrestadas. Entonces estamos solicitando libertad bajo palabra y que sea puesto en el calendario para personas sin techo porque no tiene dirección.
All right, the state is going to grant the ROR. Can you advise him that he must report for the homeless calendar on April 9th at 9 o'clock, courtroom 6-7? If he fails to report, there'll be a warrant issued for his arrest.
Entonces lo van a dejar salir libertad bajo palabra, lo van a poner en el calendario para personas sin techo, que es el 9 de abril a las 9 de la mañana en la sala 6-7. Si usted no comparece, se emitirá una orden de arresto en su contra.
Está bien.
That's fine.
Okay.
Did you say April 9th?
April 9th. Oh, thank you.
ROR, Your Honor, correct?
ROR.
Okay. No perca esto. Estás libre. Pero no perca este papel.
Emmanuel Yeshua Mendez.
Morning.
Can you state that would be Joe Carlo and I needed Joe Carlo?
Warrant on a case for.
I don't think that should be addressed right now. Okay.
Concealed weapon, is that right?
Can you?
I would advise against addressing that.
Looks like looks like it was reduced from a felony to a misdemeanor state. Let's see what the docket history shows.
Your Honor.
That can be addressed at a later time. Right now, we're addressing your bond.
Just for my own curiosity, why they need 8 witnesses. Okay.
It looks like it was bound down on April 17th of last year.
May 7th, state offer. None. PFI, what's that?
To be frank, Your Honor, I don't know.
Defendant pled not guilty and was set for trial. And I guess he failed to show for trial July 2nd. Or no, the bench warrant was issued on September 24th, so it's state ready. And the warrant was issued for 150. Defendant, I'm going to set the bond at 150 unless you have any argument you want to make.
No argument, Your Honor.
Okay. $150.
We will address that. We will address that.
For him?
Yes. Almost there.
You want me to sign it on the back there?
No, I'm looking for.
So your bond is at $150.
Oh, there's another. I'm sorry, he had another charge. Could you bring him back, please?
Come back.
I guess that's how they found the warrant.
I've requested him, Your Honor. You have one more charge.
Sorry, I'm sorry, I guess they had filed the bench warrant when you were arrested for drug paraphernalia and petty theft
Yes, sir.
at the Walgreens.
Yes.
Okay, let me see. Court does find probable cause on this case. State,
The state would be asking for standard bond, Your Honor.
court does have concern because he didn't show up for his trial, so I think standard bond is appropriate. So it'd be $500 on count one, and then 150 on count two. Is there a stay away order? No, no stay away. All right.
No, Your Honor.
Ralph Williams, fourth.
Thanks for the podium, face the people.
Mr. Williams, you're charged with resisting an officer without violence. The court will take a look at the arrest affidavit. Court does find probable cause. I don't see any prior history for Mr. Williams.
Your Honor, the state will request pretrial services for the defendant with an alternate bond of $500.
Defense?
Your Honor, because Mr. Williams has no local priors, we're requesting that he be ROR'd. Alternatively, that the bond be set at $150 with pretrial services as an alternative.
I'm gonna do pretrial services with the alternate bond at $500. Pretrial services. Jaime Lopez.
Get the bond out.
Jairo Gonzalez.
Bond out.
Elmar Matias Santos.
Mr. Matias Santos has a hold for immigration.
Okay, sir, you're charged with consuming alcohol outside of a store in Homestead. Court does find probable cause. State, position on bond.
We're asking for a $150 bond, Your Honor.
Gonna set bond at 150, given that he does have a ice hold.
Your Honor, may I respond?
Go ahead.
Oh, and Mr. Santos does need an interpreter.
Señor Santos, a usted I'm sorry, depends if you can let me know beforehand, but I think I remember. Señor Santos, a usted se le acusa de beber una bebida alcohólica al frente de una tienda. El juez ha hallado que sí existe motivo fundado y se le está emitiendo una fianza de $150, es lo que está solicitando la fiscalía.
Okay, defense, did you want to say anything?
Yes, Judge. Normally I would be requesting an ROR because Mr. Matias Santos does not have any priors and this is a non-violent offense. But in this case, I am requesting $1 bond because of his ICE holds. If you would be willing to grant that, we would be extremely appreciative.
Normalmente su señoría en esos casos estaría pidiendo libertad bajo palabra, por lo que este es un delito no violento y no tiene antecedentes, pero como él tiene una detención de inmigración, estamos solicitando una fianza de $1.
The bond will remain the same at 150 standard.
La fianza permanecerá en lo que se había dicho anteriormente, $150.
Lo siento.
Lo siento.
Okay.
Puede salir.
Señorita, ¿quién?
Tú tienes que pagar la fianza.
Yo tengo ahí en
Pero
mi
tienes que salir ahora.
Oh, okay.
Venancio Carrillo.
Sí, buenos días.
Yes, good morning.
Good morning, sir. You're charged also with consuming alcohol outside of a store.
¿A usted también se le acusa de beber una bebida alcohólica fuera de una tienda?
Sí.
Yes.
All right, the court finds probable cause.
Hallo que sí existe motivo fundado.
The state would be requesting a $150 bond.
La fiscalía está solicitando fianza de $150.
Está bien, yo lo pagaría, pero no.
No respondo. Deje que yo hablo. Tú tienes tu
Defense.
Tú tienes un hold migratorio.
You're on a bond 150?
I haven't set a bond yet on this, Mr. Carrillo. I'm waiting to hear from the attorney.
Your Honor, we are requesting that Mr. Carrillo be ROR. He does not have any prior convictions. This is a non-violent crime. And
I think you need to move your microphone.
Can you hear me, Your Honor?
That's better. Thank you.
Yes, we'd be requesting that Mr. Carrillo be ROR because he has no local convictions. This is a non-violent crime, and this is a local ordinance, and the only thing that would be holding him in jail.
Sí, señor, entonces la defensa está solicitando que lo dejen salir libertad bajo palabra. Este es un delito no violento y es simplemente un quebrantamiento de una ordenanza.
Está bien.
No es para ti, es para el juez.
Your Honor, the state would be willing to do pretrial services with an alternate bond of $150, but not an ROR.
Su señoría, la fiscalía está dispuesta a aceptar el programa de servicios previo al juicio con fianza alterna de $150, pero no estamos dispuestos a aceptar libertad bajo palabra.
Judge, it's unclear if this is a stable permanent address where Mr. Carrillo will receive.
I'm going to grant your ROR request, okay?
Thank you.
Se le va a solicitar a otorgar la solicitud de libertad bajo palabra.
No, tú no vas a pagar nada. Tú vas a salir hoy.
Kelly Butler.
Mr. Butler is a violent felony offender special concern. He's out on probation on 2 cases, F247749 and F211931.
Mr. Butler, you're charged in this case with resisting an officer without violence, trespass after warning, disorderly conduct. The court will take a look at the A form now.
Listen, yes, so, I'm so sorry. Speak English.
Can I say something?
I would advise that you let me.
No, I'll let you say something.
Okay, it can be used against you. It can be used against you.
I don't care.
You just wait for the judge to call you then.
Defense, you want to make any argument on probable cause?
Yes, Judge. As to the trespass, there's no allegation of any prior warning.
I agree.
Although I do see at the end of the A form that there are numerous signs posted, out of all candor to the court. But I don't see that he was personally warned at any point. As to the disorderly conduct, again, I reiterate my previous arguments that merely yelling, screaming, being boisterous does not amount to the level required to for probable cause of disorderly conduct. And for the resisting without violence, it's the defense's position that for a few minutes refusing to give access to fingerprints and eventually giving in to the officer's commands would not rise to the level of RWOV.
Okay.
As for the trespass warning, we agree there's nothing in the A form that says he was personally warned. As for the 2 counts of resistance without violence, defense mentioned him not willing to give fingerprints. At this point, the officer or the defendant was arrested, was ordered to give fingerprints, to which the defendant refused before eventually giving in. However, he did refuse a lawful command.
Why are there 2 counts?
I believe the failure to give fingerprints is the second count. The subject becoming belligerent and yelling after he was handcuffed and walking down the stairs, I believe, is the first count.
Okay, so the 2 counts of resisting without, I'm going to find no probable cause on 1. I guess you could make it the first count, and he'll be released outright on that count. I'll find PC on count 2. We'll address bond in a second. Count 3, I only find probable cause for trespass, second degree. And I also find probable cause for disorderly conduct on 4. So let's address his bond. Obviously, count 1, he was released outright. So state, what's your position on bond?
As for count 2, the defendant does have several convictions for either battery on a law enforcement officer, resisting a law enforcement officer without violence, or assault on a law enforcement officer. I count 6 different convictions in his priors. So we're asking for a $750 bond to count 2. For counts for the trespass and the disorderly, we ask for standard bond.
Which
Can I say something?
I would recommend that you not speak.
No, I want to say it.
Okay, I'm just recommending.
Judge, can I say something?
You can, but I would advise you not to and rely on the assistance of your able-bodied counsels standing next to you.
I still want to say this, right? I just
Okay.
want to give a brief thing, right? So my girlfriend of 14.
Remember, everything that you say is being recorded right now.
Okay, I understand that.
Helps you or not, it might not be a good idea to talk.
My girlfriend of 14 years passed away last month on the 16th.
I'm
My
sorry.
whole life changed then. I have 3 kids. I haven't seen them since then. The brother took them. I've been homeless ever since. I've been going through a tough time. My family moved to Houston, Texas. I have no one down here. So that is what I've been going through.
All right, I'm sorry to hear that, sir.
Okay, so.
So it'll be count 2, a $500 bond. The trespass is $150, And the disorderly is 150.
For the record, the defense is requesting an ROR with a date certain on the homeless calendar.
Okay, but he has an open felony case, or am I confusing that with another case?
He's on felony probation, Your Honor.
He's on felony probation for resisting. Is that, am I reading that right?
Yes, Your Honor.
Yes, Your Honor.
We would also be pressing a.
Could I please get a case number? I don't see that case.
State, is that case number F247749?
I believe so. I am double checking.
But then I see, I don't know what this means, invalid disposition.
That's specifically for a probation violation charge. Your Honor.
The clerk is going to pull it up for me right now.
I see it before me, Your Honor. There is an open violation of probation on this case, but he's not being held on it, is my understanding.
I'm going to place a felony hold on that case because he is on probation.
Your Honor, he's in custody on those 2 probation holds already, no bond.
Okay, he's on. All right, so it's kind of a moot point. This no need for me to put a felony hold. All right, so the bond stands as is. Count 2, 500. Count 3, 150. Count 4, 150. There's a stay away order from the property at 2929 Northwest 18th Avenue. 9th, right? 9th. That's right. 9th.
I can assess it. I can't imagine. I'm really sorry. Good luck, sir. Good morning. Let me just read this.
Is this okay for your get here?
I'll live with it, Judge. Don't worry. You understand? Yeah, other courtrooms say have a hard task. Hard habits, great.
What was that defendant's name?
Just 1 second. I need to read this.
Okay. Carlos Antonio Bonnet.
Yes, Your Honor.
Hi, good morning still. Or is it afternoon? I don't know.
It is afternoon, Your Honor.
We changed the time. You have 2 cases, sir. The first one is loitering and prowling at 1798 Miami Gardens Avenue. The court recalls seeing the co-defendant yesterday on these same charges. On the loitering and prowling, the court finds probable cause. You want to address the bond on this case, State?
Yes, Your Honor. We would be asking for $150 bonds.
Bond will be set at $150. Then we have driving a license suspended knowingly. Court finds probable cause. Bond.
We would be requesting $150 in this case as well.
I have to hear this.
Bond will be set at 150 in this case.
You're gonna have to pay around $100 to find out. I would advise to not speak to the judge. I want to take care of the situation.
One traffic.
I've been trying to pay it. You'll be able to. Okay. All right. You'll be able to resolve it.
Your Honor, Mr. Alvarez has a new felony. He will go to bond hearing next.
We'll see him this afternoon.
Yes, it's a new case.
All right, the first case, let's call Mr. Miguel and Alexander Alvarez Fuentes. Sure, you have several cases, including the new charge is, what is this? Unlawful possession of 4 or fewer IDs. Court finds probable cause. What's the bond on this case?
500.
We'll set bond at $500.
That's for which case, Your Honor?
That's on the case number D254612. Next one is GWLS AL5JNZE. This is a new charge, correct?
Yes.
Yes, Your Honor.
Okay. Court finds probable cause. And the bond is $150 on this case. Next.
Later this afternoon.
Just another count of actually bench warrant on DWLS for AK5BTE. We failed to appear for a trial on February 25th. The bench warrant was set at $3,500. Does this include the? No, this is just the traffic, right?
Yes. Two traffic cases.
Oh, there's 2 traffics. We'll set the bond at $3,500. Next is a bench warrant on other DWLS issues. This is AKF5YEE DWLS. Bench warrant amount was $3,500. That will be the bond amount.
It's traveling radius, not held on it. If you want to RFR it, you can just travel with it.
And there's another chart. What's the charge here?
Oh, DL expired more than 6 months.
Expired driver's license. AKF5YFE. Give them an ROR on this case.
The case ending in which letters, Judge?
It's FE, the expired driver's license.
I don't have that.
Your Honor, what case is that?
It is AKF5YFE and it is ROR. It's a criminal companion.
Oh, it's a not in custody case?
Not held on.
I'm asking you, is that an out of custody case?
Correct. Correct.
All right, he'll be back on the felony bond hearing calendar later. Joseph Petit June.
You do have one. 150, 3,500, 3,500, 500. Around 4,000.
Open B24.
Will he be on the felony calendar as well? Because I see he has an open felony case for cocaine, cannabis.
That's correct, Your Honor.
What?
On at the same.
All right, sir, you have a bench warrant case. In this case, you were charged with resisting an officer without violence and possession of cocaine, marijuana. There was an information filed. You failed to appear for a court hearing.
I'm homeless, sir, and I've been calling the courthouse and it's been very difficult. I promise I won't do that again. I was supposed to go this week to go to the courthouse myself, sir. I've been calling and they changed the program, sir. It's very difficult. I promise you, sir. I really called and tried to stay on top of it, sir. It's very
Your Honor, he also has a new felony. He will go to bond hearing next.
Please, sir. I promise I ain't.
Is that what she said?
Next bond hearing next.
Okay. I'm gonna set the standard bond on this case, which is at 150 each count. Is that correct?
It's a total of 300.
Okay, so count one, the bond will be 150. Count two, it'll be 150. And we'll address the felony later today.
All right, thank you, sir.
So that's 150 for the RWAB and 150 for the cannabis possession?
Yes.
Okay, understood.
This
It was 15th June. It's the traffic.
is the same defendant?
Yes, the defendant. He has a bench warrant traffic for no driver's license, bench warrant 2,000.
I had got this court date rescheduled. I had left the email. I was at
You don't have to explain.
Okay. All right.
Are these the same?
Yes, this is the original 8-1 when he was for the incident on 8-2.
But all of these citations are here.
Correct.
So why is there so much paperwork?
Well, because this is the stop, if you have to look at the
Okay.
stop for the incident.
But can I write everything on here?
No, not on this. On traffic, it's on the tickets. This is just for reference. You don't
Okay.
write anything in this one.
There has to be a better way to do this. This is paper. This is in the digital age of artificial intelligence. You mean that we're still writing on carbon copies of tickets? This just blows my mind that this is the way the clerk's office. I'm going to talk to Mr. Fernandez-Bartin about the way this system runs, because this should be a paperless system.
Are you to implement a system where the traffic is managed together with felons?
That CGIS computer looks identical to the way it did 30 years ago when I was a public defender. It has not changed one bit. It's the same.
Yeah, the database.
Yes.
Yes. The spirit changed, but they're separate.
Okay, sorry. I digress. Mr. Petit June has 3 traffic tickets with bench warrants. So I have 1, 2, 3, 4, 5, 6, 7, 8, 9 pieces of paper that I have to review for 3 traffic tickets.
This is the bench warrant. These 2 are traveling.
He's not held. No, there's no need to address his bond on these cases, right?
Correct. Be an ROR.
So the only thing I'm gonna address is he failed to appear on a is this DWS?
No valid.
You can't even read this.
Yeah, no valid driver's license, yeah.
But look at the bottom here where there's a box check. This is illegible.
I know that's the copy that comes out from the Spirit. That's what we have. Yes. That's a criminal mandatory report appearance, the box check.
All right, for case number AK5VCYE, I'm gonna set bond at $3,000.
Okay.
The other cases not being held on. Do I need to?
Just initial then, if you don't want to set anything with it. Just initial right here, you set the deal report right here.
Considering that Mr. Petition is homeless, $3,000 does feel a little excessive. Would you consider lowering it to $300?
Well, he has a felony case pending too, which I think he picked up a new felony charge, right?
That's correct.
So
having a lower bond won't obviate the fact that he still is going to be held on that felony.
Reset for jail report.
Yes.
So what do you do when I sign these 6 pieces of paper? Do you scan them into the system?
Yeah. I got here, it's January.
Okay, we'll see him at the felony bond hearing calendar later today.
Yeah.
Dorsaline, these?
You're gonna come back.
There.
Yeah, don't have a seat out there. Come on, Dorsaline.
Your Honor, this is Joanne Hennessy with the City of Miami Beach. Can we confirm that it's only traffic that's remaining on the calendar? And if I could be excused if that's the case?
That's what the clerk is telling me. So you can be excused.
Thank you, Your Honor. Good day.
You too. Okay, sir, you have a charge for driving under the influence.
I'm sorry, Your Honor, who are we addressing now?
It's Mr. Dorsaline.
Your Honor, the state doesn't have him on at least, oh, here he is.
Yeah. Everything else is on.
Thank you.
The court finds probable cause. Set the bond at $1,000.
Your Honor, I don't see any priors for Mr. Dorsilian. Would you consider RORing him?
I would not consider an ROR.
Do you have a stable place to live? I'm sorry, Your Honor, he only speaks Spanish.
We'll have to go back.
Thank you, Judge.
Madam Interpreter, if you can just tell him the amount that his bond was set at. And
is it Spanish?
If you could please give it to me because I don't have it, sorry.
It was $1,000 and probable cause was found.
Yes.
Señor,
Advisor charged with DUI, the court found probable cause and set his bond at $1,000.
Señora, usted se le acusa de manejar bajo los efectos. El juez halló que sí existe motivo fundado por los cargos y se le fijó una fianza de $1,000.
Tú tienes que pagar 10%. Okay. Él va a entrar ahora.
Adrian Liggins?
Yes.
Good morning, sir.
Your Honor, Mr. Liggins has a new felony. He will be on bond hearing calendar next.
Okay. Well, for this case, the court will find probable cause and set the standard bond of $450. But we'll see you for your other case later today, sir. No problem, thank you. Jonaker Danielle Zamudia.
Yes. Mr. Zamudia also has a new felony.
Spanish or-
Will be on bond for Canada.
We'll need the Spanish interpreter, Your Honor.
Thank you.
For this case, sir, you are charged with no valid driver's license,
Señor, en este caso se le acusa de no tener licencia de conducir válida.
the court does find probable cause and will set your bond at 150. However, you have a felony case coming up later today.
Hallo que sí existe motivo fundado, le voy a fijar la fianza de $150. Sin embargo, usted tiene un caso de delito mayor que se tratará en un rato.
Judge, I do see a resisting without violence. Is that attached to the felony?
It is attached to the felony.
Understood.
Okay.
Veo que tiene otro cargo que es resistencia sin violencia, pero ese va junto con el cargo del delito mayor, que se hará después.
Adrian Cruz Valentin.
Spanish? Español? Sí. He only speaks Spanish, Your Honor.
Okay.
Interpreter present.
Mr. Cruz Valentin, you're here for a bench warrant on two cases. One for no motor vehicle registration and one for driving with a suspended license.
Señor Cruz Valentín, usted está aquí por una orden de arresto por dos casos, uno por no tener matrícula de registración válida y otra es por manejar con la licencia suspendida.
You failed to appear for an arraignment with Judge Benjamin.
Usted no compareció a la lectura de cargos con el juez Benjamin.
¿Puedo explicar por qué fue?
May I explain the reason why?
Talk to your attorney first before you say anything.
Hable con su abogado primero antes de decir algo.
Your Honor, we would be requesting that Mr. Cruz Valentin be ROR'd. This was not a willful failure to appear. These are his only charges. He doesn't have any criminal cases other than this traffic violation. He was receiving conflicting information as to his court dates, did not know when he had to show up to court. He did show up to court, but on the wrong date, because he was informed that his next court date was on April 29th. So when he showed up, it wasn't on the right date and he was told he had to return on April 29th. For that reason, we're requesting that these bench warrants be set aside and that he be ROR'd.
Su señoría, estamos solicitando que él sea dejado libertad bajo palabra. Esos no fueron faltas de comparecencia deliberadas. El único cargo que él tiene son estos quebrantamientos o incumplimientos de tránsito. Él recibió información que no concordaba, fechas que le dijeron que tenía que comparecer, le dieron la fecha equivocada. Él entonces después fue a la corte unos días después de que tenía que haber estado y se le dio la fecha del 29 de abril. Por ese motivo estamos pidiendo que se le retire la orden de arresto.
What's the state for his priors?
Okay. And he did show up to court asking when his correct date was, and they said it was the 29th.
Y él sí compareció y fue el 29 de abril y le dijeron que tenía que esa no era la fecha correcta.
Call the judge and ask him to set a hearing, to set aside the bench warrants.
Y él llamó al juez pidiendo que le retiraran esas órdenes de arresto.
We can do that, Your Honor.
All right, what, can you confirm that he's still at the address on the citation?
¿Pueden confirmar si todavía está en la dirección que aparece en las multas?
Yes, Your Honor.
Sí, su señoría.
All right, so he has no priors. I'm gonna ROR him on these cases.
Bien, él no tiene antecedentes, entonces lo voy a dejar en libertad bajo palabra por estos casos.
Make sure you keep on top of these tickets, sir. Make sure, find out when your next court date is.
Asegúrese, señor, de estar al tanto, de estar pendiente de cuáles son las fechas en que tiene que comparecer.
Yeah, make sure you confirm your address with the clerk.
Y asegúrese de confirmar su dirección con la Secretaría del Tribunal.
Tú estás libre, llámame y hablaremos, ¿ok? Tú vas a salir hoy. Sí. ¿A qué hora? Ahora. Thank you. And we will calendar in Judge Benjamin's courtroom to set aside the bench warrant, just to make that clear.
Well, I set aside the bench. I set aside the bench warrant. Otherwise, he wouldn't be released. So, but that's what he should have done in the first place when he missed court. It says, "Hey,
yes, all right, thank you, Judge."
Any warrant, but I set it aside. He's our award.
Thank you, Judge.
Rowdy Apomar Aquino Tejada.
Yes.
Sir, you have a bench warrant of $3,500 for failing to appear on a driving while license suspended charge. Guess he had a felony that was no action. Does he have any criminal history, State?
Your Honor, Your Honor, the defendant does have no action felony charges. There's an F-24 for grand theft that was no action, as well as an F-24 for cocaine possession and drug possession. Both were no action.
It's my understanding that because they were no action, they should not be taken into consideration by this court, Your Honor. We'd also be asking that Mr. Aquino Tejeda be ROR'd. His reason to fail to appear was not willful. He lacks means of transportation at the moment. And he has no prior convictions, so we're requesting that he be released on his own recognizance.
The arrest affidavit says that he lives in Lake Worth, is that right?
Yes, I just confirmed with Mr. Aquino Tejeda. That's where he lives.
State, what's your position about his bond status?
Your Honor, the state would just ask that the bench warrant amount be retained. I believe it's for $3,500.
For a DWLS?
Your Honor, also printing here is a felony grand theft charge. I don't know if this defendant printed on the felony calendar.
That's the one that was no action.
It's
F24441.
So no. Okay, Your Honor, in that case, the state would stipulate the setting aside the bench warrant.
What about the bond?
The state would. There's no probable cause. If this charge was no action, there's no reason it should have been picked up on a bench warrant. So, in that case,
no, the bench warrant, I think you're misunderstanding, was for the traffic case, which was set for a trial in front of Judge Alvarez Zane in June. But there was a January of 24 felony that was no action. So the only thing in front of the court is this bench warrant and the DWLS charge.
Your Honor, the state would ask to set the bench warrant amount to $500.
All right, I'm going to do that. I'm going to set the bond, vacate, set aside the bench warrant, and set bond at $500. Have to make sure you appear in court next time, sir.
Canales.
Jonathan Walter Canales Murillo.
We will need the Spanish interpreter.
Interpreter present.
Sir, you're here for a charge of no valid driver's license.
Señor, ¿usted está aquí por un cargo de no tener licencia de conducir válida?
Court finds probable cause to. You have his criminal history pronounced.
Hallo que sí existe motivo fundado
He does not have any criminal history, Your Honor.
Okay.
y no tiene antecedentes penales.
Any objection to an ROR?
No objection, Your Honor.
Okay, he'll be released on his own recognizance.
Lo van a dejar salir libertad bajo palabra.
Rodriguez.
English?
Albert Rodriguez. Will he be here on the, I see felonies, will he be here for that later today?
Yes, George.
Yes, sir. He'll be here on his no felony.
So this is only here for the no valid driver's license, correct?
That's correct.
All right. No ticket. Court finds probable cause. What standard bond is $150.
Correct.
That's a Juan Fines Martinez. Mr. Fines, you were picked up on a bench warrant issued in 2019 for failing to appear on an arraignment on a DW arrest.
Oh, we need the Spanish interpreter.
Señor, usted fue detenido por una orden de arresto que tenía por una falta de comparecencia del 2019 por manejar con la licencia suspendida.
Suspension for failing to pay a ticket.
Estaba suspendida por no haber pagado una multa.
Your Honor, we would ask that the bond amount in this case be $250.
La,
Your Honor,
La fi-
oh, sorry, go ahead, Madam Interpreter.
la fiscalía pide una fianza de $250. Thank you.
The defense is requesting that Mr. Fines be released on his own recognizance. This is his only criminal violation. It's a traffic charge. He has no other priors. The system that these defendants navigate in is extremely confusing, and court dates often get lost, misunderstood. It's the defense's position that this wasn't a willful failure to appear. We're requesting that the bench warrant be set aside and that he be ROR'd. Alternatively, we would be requesting the standard bond at $150.
Can you confirm address?
Su señoría, estamos pidiendo que el señor Fines sea dejado libertad bajo palabra. Este es el único antecedente que tiene y es un antecedente de tránsito, no es un antecedente penal. Estamos pidiendo que sea dejado libertad bajo palabra, no fue deliberadamente que no compareció. En la alternativa pediríamos fianza de $150. ¿Pueden confirmar, por favor, su dirección?
Que estoy bajo libertad bajo
No, yo estoy pidiendo esto. ¿Tú vives aquí?
No, esa es la dirección vieja.
Ok, ¿dónde tú vives ahora?
14,
22,
Northwest, 24 Street, Miami, Florida, 33142.
Miami, Florida, ¿qué?
33142.
I just confirmed Mr. Fines's address, Your Honor. It's a new address.
Is it the one on the ticket? 1000 Northwest 74th Street?
That's not his current address, Your Honor.
La dirección actual no es la que queda en la Northwest 100 Street, no.
I will ROR him if he has to state his current address for the record so that the clerk has it.
Tiene que decir la dirección para que quede registrada en el acta y así lo dejan en libertad bajo palabra. Entonces, dígame su dirección.
Just one moment, Your Honor.
14. Sí, ahí.
Okay, yes, Your Honor. It's going to say.
1452 Northwest, 24 Street, Miami, Florida, 33142.
1452 Northwest 24th Street, Miami, Florida 33142.
Could you repeat the number again, please?
1452. 1452, ¿cierto, señor?
Sí.
Gracias. ¿Eso es casa o apartamento?
Casa.
House.
Okay, thank you.
Gracias.
Your Honor, the state would object to the ROR. The defendant does have priors. He has a conviction from 2003 that was a disorderly intoxication and also included a trespassing charge and a withhold from 2005 that was a battery felony.
Su señoría,
Sorry, Madam Interpreter.
la fiscalía tiene objeción con respecto a que lo dejen salir libertad bajo palabra. El acusado tiene antecedentes, tiene un cargo del 2003 por alteración del orden público bebiendo y también uno por intrusión ilegal y también tiene un fallo sin condena del año 2005.
So just to respond, I apologize for any appearance of misrepresentations. I do not have any priors before me in the handout that I was given. However, a withhold of adjudication is not considered a conviction for prior purposes, should not be considered by the court. And I believe the only convictions from 2003 was that the year for disorderly intoxication. That is not a violent crime. And if anything, staying out of trouble for 21 years or 22 years speaks volumes as to Mr. Phoenix's ability to abide with by the law, having only picked up this traffic violation.
He has the okay.
Tiene libertad bajo palabra. Su abogado alegó que usted no había visto que tenía sus antecedentes, pero igual son antecedentes que no son violentos y lleva 22 años sin tener problemas. El juez le otorgó libertad bajo palabra.
Gracias.
Thank you.
Thank you.
Right. Rodney Yerby.
Buenas tardes, señor. Gracias. ¿Qué va a salir hoy?
Yerby. How are you, Honor, correct?
How you doing? Good morning, Judge, Your Honor.
I think it's good afternoon, but
Good afternoon.
You're here for a bench warrant on a no valid driver's license. You did not appear for an arraignment on December 16th. You have this history?
He's out on felony bond.
You said he's out on felony bond?
Yes, F24021-313.
Is there any way you can look up the date of the arrest on that for me, please? Oh, the felony bond case.
He was arrested October 7th of 2024, Your Honor.
Okay, after the date of this ticket. Then.
Yes, Your Honor.
Is it just the is this a non-criminal traffic infraction?
Yes.
What's the standard bond for the no valid driver's license? 150. All right, I'll set aside the bench warrant and set bond on this case at $150.
What, 150? So they get out of here. So, I gotta pay $1.50.
No.
Your Honor, did you put a place to hold on the felony case?
I'm sorry.
Did you place a hold on the felony?
No.
No, okay.
The ticket predates the felony.
You're good to go.
Sound good. Get out. Huh?
Okay, Norbert Alfonso. Mr. Alfonso, you're charged with driving license suspended.
Your Honor, Mr. Alfonso is a fugitive from Hendry County, no bond.
Okay. So he has an open warrant from Hendry County, is that what you're saying?
Yes.
All right. I find probable cause on this case and set the standard bond at $150. But obviously, sir, you're being held on another case, so you'll have to take care of the Hendry case.
Wait, from which county, please?
Hendry?
Okay, thank you.
Ronald Antonio Cruz.
That's a bond out, Your Honor.
Okay. Would you like me to write that here?
Yes, that's fine.
Okay. Here too.
Yes.
And then Victor Alfonso Zamora Villanueva.
That's also a bond out.
Okay. All right, I'm going to take a brief recess before the felonies, of 10 to 15 minutes at most.
Your Honor, we also had the add-on, Mayo Juan. He was here, but he was taken back because we weren't able to contact the clerk to add him on to the calendar.
Or felony or misdemeanor?
It was a misdemeanor add-on.
You reset it for tomorrow then.
53.
All right, thank you, Judge.
And we had more than that yesterday, I think.
How many did you have yesterday?
70 something. We're shooting for 2:30.
We will do our best to help you.
We're done. Is he taking a break? He's taking a 15-minute break. It's so dark in here. Well, good luck.
Can you see who the jury was? You represent the state.
Hi, good afternoon, everybody. Is felonies next?
Yes.
Excellent. Clerk, can you please pull Adrian Liggins?
I'm not the clerk for felony. They'll be coming here shortly.
Okay.
Liggins?
All right. Thank you.
All right, I'll let them know. Take a break, 15 minutes.
Yeah, he went on the break, yeah.
Someone from correction. They were chill. I told Jack, and I was like, hey.
Dr. Jack, anywhere.
I just have like my son.
It's for you? Do you have one already?
I have one, unless it's not the right one. Number one here, that's Robinson. What does it say here?
Just maybe use this one. This one's the cover, the right cover sheet. I don't want to make you sign the wrong
It's
paper.
Robinson.
Yeah.
Okay.
Which one's this one?
I think it's the same, right?
Oh, okay, look, this one's
Paralegal.
the paralegal one. Yeah, yeah.
Okay.
Stay with that one and you'll be good.
Okay, okay.
Cool. If you need anything, or
thanks, man.
Yeah.
I was passing out my sentence for that day. I was just gonna.
Not really. I'm still tired. That's the time.
Oh, time, yeah. It really. I know.
Yeah.
I feel what.
Fourth country about it, you know.
Can we like do
West off the deer field and to the south. Yeah.
Yeah, I was like, that one party. Oh, just now. Oh, it's that on the dinner.
Can I talk to you, We won't really have time. All I'm trying to do is attack PC and
Start.
From start.
No, the Zoom is asking for it. We don't have it. There's a link in.
page 18. Christian Renee.
Kristen Fernandez.
Don't stop moving all over it.
Is the felony staff in yet?
Yeah. Yes, how can I help you?
Madam Clerk, could I please get Adrian Liggins called out of turn, please?
Adrian Liggins. No, thank you.
Can the courtroom hear me? Hello?
Oh, yes.
Okay, thank you.
Council, what's the base number for Adrian Liggins?
F24. I mean F25. 4857.
4857.
Yeah, he's on page 9. Oh, you got some.
Pardon me. Do you know which button I push to mute and unmute? Because there's, it looks like there's two speakers. I'm not sure which one it is. Is this the one I touch?
Yeah.
So don't worry about that one.
Don't worry about that.
Okay.
Got video. And the green is on.
Thank you, ma'am.
Could somebody please answer me if Adrian Liggins is on calendar this afternoon?
Do you have any more? Do you have any more?
Adrian Liggins, Liggins.
He's on the calendar this afternoon.
Okay. And felonies is next?
Yes,
Okay. Can I please get that case called out of turn?
no problem.
Okay, thank you very much.
You're welcome.
Got my glasses up, waiting to put them on. I think his name's earlier.
I think I did see a popular. Actually found it. Yeah. Yeah, so we have 9. You get the right room?
Let's see, what is this file right here?
No. Correction.
I've been here, big before that I've been here. Here. Okay, so. But I'm a pro days.
Yeah.
Cause I like to go to the farmer's market on the weekend. You know? Yeah. I don't get to go. Yeah, I'm sharing and I'm yellow and green, yellow and green.
What's the last name?
Next person. Guess what?
What number is Pablo? What number is Pablo? No. Pablo. That's Pablo. That'll be called around, but like, I try someone to remember where that. I can send it to you. You want to, like, the demo, I'll text you. I can call them. Let me see. So, 263, 263, video. But Pablo, he's not on that calendar. Pablo, he's not on the calendar. Hello.
No.
We have some other terms.
Yeah, this.
One, we're gonna stop.
Private counsel
Yeah,
or?
one is private counsel and the rest is for corrections.
Okay.
Yeah.
So like stack, I don't know if that's gonna.
We have a new public defender here for felonies.
Yes, Judge. Good afternoon. Angel Black for the Public Defender.
Is it Mr. Black?
Yes, sir.
Good afternoon.
Good afternoon, sir.
Do you need to swear them in or?
Oh, mine, yeah.
All right, so raise your right hand.
Todos de pie y levanten la mano derecha.
All right, so raise your right hand. Do you swear from the testimony about to give me the truth, the whole truth, and nothing but the truth, sadly?
Juran decir la verdad, toda la verdad y nada más que la verdad, diga lo juro.
Okay, the first case I have is Adrian Demetrian Liggins.
Good afternoon, Your Honor. Scott Saul for you. I've never had the pleasure of being in front of you.
Good afternoon, Mr. Saul. A pretty poor connection. I don't know if you're on Wi-Fi or cell phone. I don't know if you can improve your.
Is this better?
It's a little better, yes.
Okay, Your Honor, this is a possession of firearm by a convicted felon where my client is a truck driver and it's the result of an innocuous traffic stop. I'm respectfully asking for a $5,000 bond. Other than the alleged charge, the gun is not attached to any other criminality. Yesterday, I filed a permanent notice of appearance. And so as far as risk of flight, I've already dedicated myself to being there for every court date for the client.
All right, let me take a look at the arrest affidavit.
And I apologize for my attire. I just learned about this a couple hours ago.
Your Honor, on his traffic, you gave him $150 bond.
Okay. The court does find probable cause. Let me hear from the state as to their position on the bond.
The defendant does not have any local priors. His NCICs are reflecting forgery convictions out of Marion County. We would have no objection to a $5,000 bond.
Okay, bond will be set at 5,000.
Thank you, everybody. Have a great weekend. Bye.
Thank you, John. The other case is the corrections, what I recalled was this one. Christian Fernandez.
What number is that, Your Honor?
We signed for the out of facilities. Defendant refused court.
This is, I think he has several cases. He's on page 18 of the calendar.
Thank you, Judge.
We have 3 cases today, and I don't know if there was a.
There's 5 cases and we can.
So he's refusing?
What number did you want?
This is the second day. Defense, do you want to waive his presence or just I'll reset it for tomorrow?
Just reset, Judge. Thank you.
Okay. Let me make notes on all these. I have so many paper clips here. I don't know what's going on. This is a misdemeanor case. No, felony. Felony
case drawn.
All right. Reset to March 10. These are Mr. Hernandez's cases. Then in a particular order, I have 2 files. Okay, Ronaldino Perez Moreno.
Defendant refused as well, Your Honor. Reset for tomorrow.
All right.
Corrections, what number is that?
52.
Here.
I didn't get it actually.
Michael Eves Devot.
The defendant refused. Reset for tomorrow.
Antonio Viveros.
Defendant refused, reset for tomorrow, Your Honor. So has the immigration hold.
Alvaro Jaramillo.
Defendant refused court, Your Honor, reset for tomorrow.
Reset. You want the paper clips or? Jeffrey Jerome Hepburn. Is Mr. Hepburn there?
Ward D, Your Honor.
Okay, I'll reset to 310. Terry Maurice McCray.
Defendant refused, Your Honor, reset for tomorrow.
On all of his cases.
Yes, they added 3 more.
Reset to 310. This point, correct?
I've been working back here. I'm gonna say goodbye since I just learned that the defendant in my matter bonded out.
Okay,
So
thank you for stopping by.
I figured I should at least say goodbye since I've been working back here. Have a nice day.
You too. Thomas Jefferson Williams.
Defendant refused, reset for tomorrow, Your Honor.
Great. Brandon Lee Neely.
Your Honor, he refused as well, reset for tomorrow.
Reset. Tony Kane.
Defendant refused, reset for tomorrow, Your Honor.
Set 310. Robert Grotto.
Defendant refused, reset for tomorrow.
Set 310. Timmy Williams.
Defendant refused, Your Honor, reset for tomorrow.
Set 310. Roberto Perez Torrens.
Defendant refused, Your Honor, reset for tomorrow.
Set 310. Yarvain McKenzie. Mr. McKenzie.
He's en route, Your Honor.
Yeah. Your Honor, Mr. McKenzie is a fugitive from Broward County being held no bond on. He's also out on probation on F-23-797.
Okay, Mr. McKenzie, on this case, you were arrested for possession of marijuana with intent to sell within 1,000 feet of a school, possession of cannabis more than 20 grams, possession of drug paraphernalia, and a municipal ordinance violation related to marijuana. Court will review the affidavit for probable cause. Are there any arguments to probable cause defense?
Mute on PC, Judge, and my apologies. Can you please provisionally appoint the public defender to all forthcoming cases?
I will appoint the public defender provisionally on all cases today.
Accepts appointment.
Okay, can you show me where it identifies that this wasn't 1,000 feet of a school? It says Loomis Park, but I don't see school. Or is there a difference?
This was an add-on, Your Honors. I'm just reviewing it myself.
Okay.
Your Honor, under the statute, it does say that this is charged with, that it also includes coming within 1,000 feet of real property compromising the state, county, or city park.
Thank you.
Of course, Your Honor.
All right, the court does find probable cause. What's the state's position on bond? Obviously, he has a felony. He's on no bond status on other cases, but for this case,
We do not have either his NCICs or his local priors for an add-on, so we're just asking for standard bond.
okay, so the first charge is a second-degree felony would be 5,000. Is that correct?
Yes, Your Honor.
Second one is possession of marijuana more than 20 grams. Third-degree felony, $2,500.
Yes, Your Honor.
First-degree misdemeanor is what, 500 for the possession of paraphernalia?
Yes.
And then the municipal ordinance is that 150?
I believe so.
Count 1 and count 2 was 2,500, Your Honor.
No, let me just clarify. Count 1, the bond is $5,000. Count 2, it is $2,500. Count 3 is 500. And count 4 is 150.
Be hold for F-23-797 out on probation.
Yes, so put a felony hold on case number F-23-797. Madam Clerk, you want to go right up here where this is? Do you want me to put my notes here? Diogenes Manuel Santana. I threw it's got it. Mr. Santana, you're charged with false imprisonment, domestic violence, battery by strangulation, and strong arm robbery. The court will take a look at the arrest affidavit now for probable cause. The court finds probable cause, but will entertain any argument if defense wants to make.
Thank you, Judge. I don't see any allegation that they're currently in a dating relationship or that they reside together, which is required under the statute.
It says ex-boyfriend and girlfriend.
Yes, Your Honor. I believe the statute specifies that it's a current dating relationship, unless I'm wrong.
Here from the state.
That's correct, Your Honor. It says they're ex-boyfriend and ex-girlfriend, and they used to reside together as a family, so that takes this out of the realm of the domestic violence statute.
So would it be straight battery then?
That's correct.
Okay, so court finds probable cause on false imprisonment. This, and for count 2, the court finds probable cause for simple battery. In count 3, the court finds probable cause for strong arm robbery. Can you address the bond state?
Yes, Your Honor. And I
Do
apologize.
you have priors on him?
This was an add-on as well, so we don't have priors for.
All right. So for count 1, the false imprisonment, which is a 3rd-degree felony, is it 2,500?
We would ask for 2,500, Your Honor.
Count 2 would be 1,000.
That's correct.
And count 3,
Your Honor.
strong arm robbery, would be
5,000, Your Honor.
Any argument from the defense?
No, Judge. Standard bond is fine.
Okay. As I stated, in count 1, 2,500, 2, 1,000, 3, 5,000. There's also going to be is there a stay away order being prepared?
There will be, Your Honor.
Okay, so I'm going to order you to stay away from the alleged victim in this case. I don't know if we have the name. This is your ex-girlfriend. If you do bond out, you cannot reside together. You have to find temporary living arrangements elsewhere. Okay.
Yes, sir.
In,
Thank you.
okay. Your Honor, I believe we actually can't issue a stay away order in this case. The copy of the arrest affidavit we were handed doesn't have the victim's information, and it's not in the 4 corners of the arrest form.
Okay.
It's not gonna be in there yet.
And no stay away order will be issued at this time. Sure, you can have the division prosecutor take it up. Tejeda, McCollum, Robinson.
All right, Ms. Robinson.
Your Honor, on her misdemeanor, you gave her a bond of 300.
Well, that was this morning, right?
That's correct.
Okay. So, ma'am, you're here for a possession of cocaine, possession of drug paraphernalia, and resisting and petty theft. So a total of 4 counts. Let me review the arrest affidavit. Court does find probable cause. Is there anything defense wants to argue?
Mute on PC, Judge.
Okay.
We would only ask for, instead of standard bond, TAP Judge, which is a program for homeless folks who can't afford bond. She can't afford bond, with an alternate bond of the standard bond judge.
This day would stipulate to that, Your Honor.
Alternate program?
Yes, Your Honor.
Mm-hmm.
And I did just want to raise, I do think there is a bench warrant for an open B25 case that was issued on February 26th.
Didn't I address it this morning?
You did, Judge. You said it at 300, matching the bench warrant amount.
Okay, so let me go back. Okay, so it would be TAP with the alternative bond, correct?
Yes, Your Honor.
Help me out here. All right, the alternative bonds would be
The alternative bonds,
would it be 2,500?
that's correct. For the possession, it would be 2,500.
500
for drug paraphernalia, 500 for the RWOF, and 150 for the petty theft.
Okay, ma'am, you'll be released to the alternative program if they will accept you. If not, you will have to post standard bond if you want to get released. I'm also ordering you to stay away from the Dollar Tree at 120 Northeast 8th Street, Homestead. Lysandra Rochelle Johnson. Ms. Johnson, you're charged with grand theft, the organized scheme to defraud, possession of a fake ID, uttering a false forged instrument, worthless check, and possession of a stolen or fictitious driver's license. Court will take a look at the affidavit. Arguments on probable cause?
I'm sorry, Judge, did you ask me about probable cause?
Yes, do you have any arguments on probable?
We stand mute as to counts 1, 3, and 4. With respect to count 2, organized scheme to defraud, the statute criminalizes systematic ongoing course of conduct. When I read the A form, I see a singular incident, a singular attempt to commit a grand theft. And so I would argue that there's no PC on that count, Judge.
Okay, state your response to the count 2 charge.
The state would agree with the defense, Your Honor.
Okay. So on count 2, the court finds no probable cause in that charge. She'll be released outright. You set the standard bond for the other charges, grand theft, 2,500. State.
Yes, Your Honor.
Count 2 is a release.
That's a release outright, Your Honor.
On count 2, yes, corrections. And count 3, is that also 2,500?
Yes, Your Honor. The remaining counts should all be 2,500.
And counts 4, 5, and 6 are each $2,500. There's also going to be a stanley order, ma'am. You are not to go to the Amscott check cashing store on Southwest 137th Avenue. Denise Marie Torres Garcia.
She's being brought, Judge.
Ms. Torres Garcia, you charged in this case with conspiring to deal in stolen property. Um, Eight. And
Your Honor.
I don't understand the probable cause for this charge. Maybe another charge, but I don't see it for dealing in stolen property.
Yes, Judge, there's no actual factual allegations.
So there are two other, I have the arrest form in front of me for F-25-4886. There are two other F-25 cases that have an arrest date of 2 days ago.
She received bonds on those cases. On F-25-4831, she received a bond of $3,000. On F-25-4847, she received a bond of $150.
Okay.
Right, but that doesn't address this case, which I have to look at the four corners of the arrest affidavit to see if there's probable cause. Says she was observed organizing, planning, directing, and supervising the theft of the victim's I missed that number. 18 black scooter. I don't know what that means.
I would assume it's just the scooter type.
Or is it I-8? I don't know.
I think it could be either, Your Honor.
Anyway, it's not 18 scooters, right?
Yeah, I think that's correct.
So address probable cause on this.
I'm checking the other 8 forms, Your Honor, to see if they explain.
But I can't do that.
Yeah.
I have to go on what's on the face of this affidavit.
I would say, Your Honor, while there isn't much detail, it does say organizing, planning, directing, and supervising the theft of a scooter belonging to the victim. Which
Your Honor, I'm sorry.
Go ahead, counsel.
My apologies for interrupting. I would just say, Your Honor, that those are legal conclusions. So, Your Honor, there's no factual allegations underlying those legal conclusions. There are no factual allegations in the four corners of the arrest form.
The state would be inclined to agree with that.
There you go, Mr. Black. The state agreed with you.
Thank you,
Write a note in history for future reference. The state agreed with Mr. Black.
Will, Judge.
So the court finds no probable cause based on the agreement of the state. And on this case, the defendant will be released outright. Holly Lynn Raimondi.
Your Honor, she's gonna be a reset medical.
Okay. Reset to 310. Katie Lee Adams.
Reset medical, Your Honor.
Reset, pretend. Shelniqua Portier. You have two cases? Yes, I have two cases with Miss Portier. First case, ma'am, you're charged with an aggravated assault with a firearm, resisting an officer with violence, and criminal mischief. Court will take a look at the affidavit. For case number 254878, the court does find probable cause. You have her criminal history state?
I do, Your Honor.
I would be inclined to set the standard bond unless there's something else you want to point out.
No objection, Your Honor.
Okay, so it'll be 2,500, 2,500, and 500, right?
It should be 150
150 and
on the premise.
okay, count one, $2,500. Count two, $2,500, and $150 on count three.
Your Honor, pardon me. So we would ask for either pretrial services or GPS monitoring. She doesn't have the money to bond out. And so I'll let you review the next case, but we'd be asking the same on both.
No, the court is very disturbed by the seriousness of the allegations of threatening someone with a firearm, and it does not believe that the community can be protected. So I'm setting a standard bond. These are very serious allegations. Obviously, they have to be proven beyond a reasonable doubt, but for purposes of probable cause, it's very serious. The next case is 254882, battery on a police officer or firefighter. Apparently related to the other case, the defendant allegedly kicked the arresting officer several times in his legs. There are two counts of battery on a police officer or corrections officer. Is there two different victims, state? Is that why there's two counts? Or was it two separate incidents? I'm trying to figure it out.
I believe it is only one victim, Your Honor.
Deputy Paul?
It looks like it is Deputy Paul.
Oh, there's two different
and there are two different officers and Deputy John Baptiste.
The court also finds probably the cause here. That's the standard bond of $2,500 on each count.
It should be 5,000, Your Honor, because it is a secondary felony with force.
Judge, I can't afford it. Can you please work the pretrial with me, please?
No, ma'am, I'm sorry, but there's a very serious allegation. Number one is that you threatened someone with a firearm. Now, these are just allegations, you're not proven, but the second one is that you kicked two police officers engaged in your arrest. So, you're not going back to the state, but it says third-degree felony state.
Correct, Your Honor. Under the uniform bond schedule and pretrial release procedures, It says for persons not covered under 3A, arrested for a third-degree felony that involves any amount of force or threat of force, the bond is $5,000.
I'm sorry, State, can you repeat that statute?
It is the Uniform Bond Schedule and Pretrial Release Procedures. It's the administrative
Thank you.
2023-03.
So, Your Honor, they're 5,000 each now?
Yes, there are $5,000 on each count.
I don't have.
Alexandra Lynn Howard,
4D, Your Honor, reset for tomorrow.
reset March 10th. Apparently they're having some issues moving in the last minute. So I'm gonna wait. Mr. Black, I don't know if you heard, but the last defendant was reset.
We did miss that, Judge. We were dealing with something here. What was the name of that defendant, Judge?
Is Alexandra Howard, Ward, was it Ward D? She was at Ward D.
Yes.
Jose Luis Benitez Enriquez. Sir, you are charged with possession of a controlled substance suspected of being THC, burglary of an unoccupied conveyance, assault, resisting an officer without violence. I'll look at the A form to see if there's probable cause. Was the vape pen or the drill the victim's property? If you read the sentence, it's not perfectly clear, is it?
It is not, Your Honor.
All right, the court does find probable cause.
Your Honor, defense has probable cause arguments.
All or which counts?
On count, 1 and 4.
Okay, possession of suspected THC. Go ahead.
Yes, Your Honor. So there's no allegation, and in fact, no way of knowing whether the THC in possession was scheduled or non-scheduled. Non-scheduled THC is sold in every smoke shop in Miami. What's more, there's no actual allegation that it is THC. There's no allegation of a smell or a taste to prove that it's CBD, not CBD, that it's not nicotine. I don't think the officer took a puff of it in order to know. So I'm not sure how the officer knows that it's THC and or that it's scheduled THC. Now, with respect to count 4, there's actually in the 4 corners of the A form no allegation that he was detained pending investigation. Per the allegations contained in the arrest affidavit, it very well could have been a consensual encounter.
We hear from the state. I guess this is counts 1 and 4.
As to count one, there is nothing in the four corners of the affidavit that say why they suspected it was THC, just that it was suspected THC. As to count four, it does say that they did ask the defendant to identify himself, at which point he refused to provide his identification, which is our understanding as the basis for the resisting without violence.
I would just quickly follow up, Judge. In order to detain somebody, in order to ask their identification, there has to be reasonable suspicion. And reasonable suspicion is an element of the ROF statute. And also, the defendant knowing that he's detained is an element of the ROF statute. So if he didn't know that he was detained pending investigation, then he had the right to refuse to provide his identification.
Okay, the A form does say that they responded in emergency mode and the defendant matched the description of the person who stole tools from the vehicle. But with respect to count one, the court will find no PC to be released outright. Do you have any prior history on this defendant?
He does not have any priors now.
Okay, what is your position then on bond or custody release?
As to the remaining counts, we ask for standard bond.
Defense?
One moment, Judge. So, Your Honor, we'd ask for a pretrial services with the alt standard bonds. He can't afford the standard bond.
But he doesn't have an address according to the arrest affidavit. Does he have a local address?
Okay, so Your Honor, he does not have the address at the top of his head now, but he just moved into a location. He has a number that PTS can call. It's its landlord. They can verify the address. So as long as they can do that, he could be released on PTS if you were to grant it. And he does report that he's employed at the moment.
We'll do pretrial release. The alternate standard bond on count 2 is what, 2,500?
Yes, Your Honor.
Count 3.
Count 3 should be $250.
And 4 is 500?
500, yes, Your Honor.
Okay, before you leave, I have 2 stay away orders. You need to advise them. First is, sir, you have no contact with Zulima Venero or Gabriel Garcia Mendez. Gregory Cardullas.
Yes, Judge, he's here.
Sir, you're charged with aggravated battery. The court is going to review the affidavit.
Your Honor, the state would actually. The state finds no PC for an aggravated battery on the four corners of the arrest form. The state would argue that there's probable cause for an aggravated assault with a deadly.
I was waiting to see where the battery was. Mr. Black, the state concedes there's only a PC for aggravated assault, not ag bat.
Yes, Judge, I was about to make that argument. Thank you.
I agree with the state in their well-reasoned concession. What is the bond recommendation?
The state would ask for 5,000.
So, Your Honor, defense is going to ask for release on recognizance for a recognizance bond. This gentleman has 0 priors. He's never even been arrested. The allegations in the document make it clear that he was responding to the scene because his employees were calling him for help because there was a man who was threatening burglary and battery. This is clearly a self-defense situation, and there are witnesses. So, Your Honor, he's not a threat to the community. He's not a risk of flight. He's a business owner. I think that Your Honor is entitled to consider the nature and circumstances of the offense and possible outcomes. And I think that this is very susceptible to a stand your ground defense if it's not dismissed before that point.
Let me read it one more time, okay?
He's also a homeowner, Judge, so he's not going anywhere.
No prior history, right, state?
That's correct, Your Honor.
Certainly, the arrest affidavit does raise some questions as to whether or not he was justified in doing what he was doing. So, does pretrial services take not an ag assault?
Your Honor, I do think that a question of stand your ground or justification could better be addressed or considered by the prosecutors after this case. But as far as PC for aggravated assault, taking out a firearm and pointing it at somebody meets that requirement.
So, Judge, we're not arguing PCS to an ag assault. We're arguing over bond. And Your Honor, okay. Your Honor, in your discretion, can consider the nature and circumstances of the allegations.
They would be willing to do a $3,000 bond, but the state would not stipulate to an ROR.
Can your client make a $3,000 bond?
That's fine, Judge.
Okay, I'm going to set bond at $3,000. Given there appears to be some mitigating circumstances set forth in the arrest affidavit. But I'm also going to order you to stay away from the alleged victim. Do we have the name or no?
The alleged victim's name is Rodney, Your Honor.
Okay. There does no contact with Mr. Martin. Obviously, sir, this is not the trial. This is just probable cause. So you will have your day in court later. I'm setting the bond at $3,000. Charlie Murthill,
The bond out.
Out.
bond out.
Yes.
Thank you.
Mr. Perez Hernandez is out on felony bond, Your Honor, F-24-5954.
Yes, I see the bright pink sticky note on the A form that I will not remove under penalty of, because the clerk chastised me for removing a Post-it note. Mr. Perez Hernandez, sir, you're charged with trafficking in cocaine and possession of marijuana less than 12 grams. Is he here? Is this Mr. Perez Hernandez?
This is him, Judge.
Here, the court does find probable cause.
So, Your Honor, defense would make a probable cause argument about count 2. Again, this is the cannabis and THC issue. There's no allegation that it's scheduled versus non-scheduled. There are smoke shops all throughout the Miami that sell, green leafy substances that smell like cannabis, Judge.
Still find probable cause. Let's discuss the bond status. Does he have a criminal history?
Your Honor, the defendant does have a criminal history, however, to all of the previous charges appear to either be no cross or no actions counts. There is, as corrections mentioned, the open felony. So the state would ask for a $500 bond for each count and a felony hold.
So, Judge, defense would just ask for a $1 bond on each. He's going to be held no bond on the other case.
You don't have this as a first-degree felony, right? I think the $500 bond is reasonable.
Okay, Judge.
So it'll be $500 for each count 1 and count 2. And there's a felony hold for F245954. Patrick Vidal. Mr. Vidal is charged with possession of suspected crystal meth and trespass to a structure of conveyance. Court finds probable cause. criminal history state?
Yes, Your Honor. There is an M24 conviction for drug paraphernalia, threatens to a law enforcement officer, disorderly intox, and a controlled substance possession.
Misdemeanors?
They're misdemeanors, yes. And I apologize, the controlled substance was not a conviction, it was withhold. So we're asking for a slightly elevated bond of $3,500 for count one, and then the standard $150 for count two.
Defense?
Judge, given his lack of, I'm sorry, I'm not sure if the state mentioned that there were any felony convictions.
I don't think there's any felony convictions.
In light of that, Judge, and the fact that he can't afford to pay anything, he's homeless, we asked for the TAP program with alt bonds.
Okay, I'm gonna do referral to the TAP program. Alternate bond would be the standard bond. $2,500 count one and $500 on count two.
I do have a stay away with Your Honor.
Okay. And sir, you to stay away from 1683 Alton Road where you were arrested. I'm sorry, Madam Clerk. It's a third-degree felony, right?
Count two, standard bond would be $150, Your Honor.
Oh, sorry. 150. Thank you.
Tap 2,500, count two, tap alternate 150.
Yes. Gregory Martin.
He's coming, Judge.
Is this Mr. Martin?
Yes.
Mr. Martin, you're charged with burglary of an unoccupied structure and criminal mischief. I'll take a look at the arrest affidavit. Any argument to probable cause?
Yes, Judge, we have argument as to count one, burglary of an unoccupied structure. So the criminal mischief in this case, it preceded the entry into the structure. So there has to be an allegation of an intent to commit a criminal offense inside the structure after the burglary, and I don't see that allegation in the A form.
The state agrees with that, Your Honor.
But he was in the property?
So
Trespass?
the state would ask Your Honor to find probable cause for trespass.
So, Your Honor, the jury instructions for burglary make clear that a trespass is the lower included. So the criminal offense therein cannot be trespass. It has to be something else.
I'm not asking him to find probable cause for burglary. I'm arguing that there is no probable cause for
Oh,
burglary.
my apologies.
They're not charging me with burglary?
You had him at hello, Mr. Black.
Sorry.
Huh?
So they're not charging me with burglary?
So
So there's no PC for burglary, but probable cause for a trespass of a structure, which is what? Is that first degree?
I believe because there was no warning, it would be a second degree.
All right, so that'd be 250?
The state would agree to a $250 bond.
So Your Honor,
250?
Yes, Your Honor.
so Your Honor, I would just ask, Mr. Martin just represented to me that the Miami Homeless Trust gave him an apartment. Or
just got it
hold
2
on,
days
hold on
ago.
a second. Provided an apartment 2 days ago. So if we give him PTS, he can provide the number for the Miami Trust. They can confirm that he has an address, and he can go back to that address. He's telling me that if he doesn't attend all house meetings every week, that he'll lose the apartment. And so we're asking for PTS with the alt bond.
Okay, pretrial services alternate bond is $250 on count 1 and count 2. And stay away order from is this a church?
It is a church.
Do you know the name of the church? No, you don't.
No, Your Honor, it's not mentioned in the arrest form.
Okay, Mr. Black, tell your client and Mr. Martin, you have to stay away from the property where this occurred, 810 Berry Street.
So Your Honor, my apologies. Mr. Martin is panicking a little bit. He's asking for ROR. He's worried that corrections.
I promise to show, I'll never not show up. I'll make sure I'll go to court, sir.
He's worried that corrections will not be able to reach the Miami Trust, and so that he won't get out.
I'll go right to the Miami Trust and then get that information. And my apartment is just 3 blocks from you guys. It's in River Landing, and I'll take that personally to you the next court date. I have a good history of showing up to court, sir. I promise you I will be there, and I'll promise you I'll bring the information to you personally the next court date. I just have to get it from
me
because I only had.
I just settled cases in the South Bay courthouse. I'm here for bond hearings only this weekend. So what, do you have a criminal printout on his history?
Judge, I see 1 adjudication for a misdemeanor of park after hours. Everything else seems to be withholds. I don't see any convictions on any felonies.
I have no felonies, sir.
So why would corrections, are you here from corrections? Pretrial.
They will make a phone call to try to reach the individual if they're there, because it was the weekend, and I don't know.
No, they couldn't call until tomorrow, obviously.
No, they'll try to call.
They'll try to call today? So who are they gonna call to verify?
I don't even know. I'll have to go to the Miami Beach Homeless Trust and get that information, and the address and everything. It's in River Landing. It's just right down. You know where the Winn-Dixie is, and right past the Publix, in River Lane, right by your guys' courthouses. It's like a 3-minute walk from your courthouse, sir.
I'm not from South Bay Justice Center. I'll tell you that.
Oh, I'm sorry. I thought this was the 6-7 courthouse, the Richard E. Gerstein building, but it's right by the Richard E. Gerstein building, and River Landing, Your Honor. I promise I have a good history of showing up to court, and I'll bring that information to the proper place if it has to be the public defender office.
Judge, would you be amenable to giving him a date certain to show up to court?
I'll be there. I promise you.
On the homeless calendar?
Yes, Judge.
Would he still qualify for that? I mean, as of today, it says homeless on the arrest application.
Can we keep it that way? And then when I give you the address, we can change it then?
All right, this is what I'm gonna do.
I appreciate you, Judge.
Just wait.
I am going to give him an ROR and order him to report to the homeless calendar on April 9th at 9 a.m. If you don't show up, there's gonna be a bench warrant for your arrest, sir.
Yes, they'll give me the information where I'm supposed to be, right, Judge?
Now, your attorney's gonna give it to you right now. This is it.
Hey, Your Honor.
Okay, stop talking.
Just listen.
April 8th? They were telling me the 9th this morning. Because I told everyone this morning the 9th. That's what my sticky says 9. Yes. Oh, this is April 8th for the felon. Well, these are misdemeanors or, well, there's PC for April 8th. I don't want him to miss court.
I'll show up both days if I got to.
There you go.
Thank you. I'm very appreciative of you, sir.
Okay. Good luck to you.
Thank you.
Lázaro Alvarez.
Your Honor, he has a hold for immigration.
Your Honor, this defendant will need the services of an interpreter.
Interpreter present. Yo le voy a servir de intérprete.
Mr. Alvarez, you're charged with possession of crack cocaine.
Señor Álvarez, se le acusa de tenencia de cocaína crack.
The court finds probable cause.
Hallo que sí existe motivo fundado.
Okay, custody, bond.
There are no priors, so we're asking for a standard bond of $2,500.
Mr. Black.
No tienen antecedentes. La fiscalía está pidiendo fianza de $2,500.
Judge, I don't have the ability to speak to my client about his financial situation, but given that there's no priors, we'd be asking for either PTS or ROR. He seems to have an address.
Su señoría, no tengo la posibilidad de hablar con mi cliente en este momento, pero para averiguar su estado financiero, pero sí puedo decir que él no tiene antecedentes. Estaría pidiendo el programa de servicios previo al juicio o que se deje salir libertad bajo palabra.
Do you live at 328 East 13th Street in Hialeah, sir?
Señor, ¿usted vive en la 328 East 13th Street de Hialeah? Yes.
Okay, I'll order pretrial services, alternate bond, $2,500.
Entonces ordeno que lo dejen salir bajo el programa. I'm sorry, Judge.
They just reminded me he has an immigration hold. So that changes everything.
Un momento, porque es que usted tiene una detención de inmigración.
What say you, Mr. Black?
Yes, Judge, he's got a nice hold, so PTS is not going to get him out. So I suppose standard bond is where we're at.
Standard bond, $2,500.
Sí, como tiene una detención de inmigración, el programa de servicios previo al juicio no lo dejarían salir. Entonces, sería la fianza estándar de $2,500.
Michael David Valdez.
Out on felony bond F25-1762.
I see the pink Post-it note. Mr. Valdez, you're charged with petty theft with prior convictions, 2 prior convictions at Walmart. Where does it say in the body of the narrative, the entire prior conviction?
That's a good question, Your Honor.
I try to ask good questions.
I'm sorry, Your Honor, I missed that good question. What was that?
The good question that I asked is, where does it say that he has prior convictions in the narrative?
Precisely, Judge. There's no PC for felony petty theft.
I sometimes try to ask good questions.
Your Honor, the state would ask you to find PC for misdemeanor petty theft rather than felony petty theft.
So PC for misdemeanor petty theft only. And the bond on that is
Your Honor, I believe it's $250, but because he does have 2 prior petty theft convictions, I would ask you to set bond at $750. And in addition, to place him under.
Mr. Black, what say you?
So, Your Honor, he's going to be before whichever judge is presiding for F-25-176.
Felony hold. All right, so I'm gonna just set this to the bond at 250 in this case. Felony hold on case F-25-1762 for Judge Lopez. Is there a stay away order? I don't see one.
There is a stay away, Your Honor, for Walmart.
And sir, you're also to stay away from shopping at Walmart at 9191. That's what I believe.
That's correct, Your Honor.
Nathan Pozos.
Can I have him out on felony bond on F-25-2829?
Mr. Pozos, you're charged with possession of cocaine and marijuana. Court finds probable cause.
Your Honor, the defendant does have quite a few convictions.
Well, he has also, I'm going to be putting a hold on the felony, so.
And so, Your Honor, the defense would make the same argument about the cannabis for count 2. There's just no way of knowing that it's something that's actually scheduled, actually unlawful. I don't see any allegation, any investigation to determine whether that's the case.
Other than the statement that he has marijuana on him.
Right. You can go into many drugstores or, excuse me, smoke shops throughout Miami and say, I would like to marijuana, and it would be completely legal marijuana.
Well, I'm going to find probable cause. The standard bond for count 1 is 2,500. And for 2 is it 500 or 250?
500, Your Honor. 500.
500. And a felony hold for the other case. You'll have to appear in front of Judge Hirsch, sir, on your felony case. Manuel Lopez Ramirez.
So, Your Honor, we'll need the services of the interpreter.
As a whole for immigration.
¿Usted tiene una detención de inmigración?
Mr. Lopez Ramirez, you're charged with aggravated battery with a deadly weapon.
Señora, usted se le acusa de agresión física con agravantes con arma mortal.
The court finds probable cause.
Hallo que sí existe motivo fundado.
State, what's your position on bond?
Your Honor, the defendant has no priors, so the state would be asking for a $5,000 bond.
Su señoría, el acusado no tiene antecedentes, dice la fiscalía, entonces estaríamos solicitando una fianza de $5,000.
Mr. Black?
So, Your Honor, it's not going to matter much because he's got an ICE hold, but if he didn't, I would ask you to take into account that he doesn't have priors and there is prima facie an allegation of stand your ground here, which you can take into account. I don't have the ability to speak to him about his ability to pay a $5,000 bond, but again, he's got the ICE hold.
Su señoría, él igual tiene una detención de inmigración, pero de todas maneras quisiera que se tomara en cuenta, si no tuviera esa detención de inmigración, que él no tiene antecedentes y aquí es posible que se pudiera alegar que estaba en defensa propia. Pero igual, como no puedo hablar con él, no puedo averiguar si tiene la posibilidad de pagar esos $5,000 de fianza.
All right, I'm going to set the standard bond, which is $5,000.
Voy a-
Have an immigration hold, which would probably preclude you from bonding out. Is there-
Voy a,
Yes, Your Honor, there is a stay away order for Pedro Lopez Ramirez.
I'm also ordering you to stay away from Pedro Lopez Ramirez, who looks like is your brother.
Bien, entonces le estoy emitiendo una fianza de $5,000. Tenga en cuenta que usted tiene una detención de inmigración, seguramente no lo dejarán salir bajo esa fianza. También le estoy diciendo que usted tiene una orden de alejamiento, tiene que mantenerse alejado de Pedro López Ramírez. Aparentemente ese es su hermano.
Okay, sir.
Ya es todo.
John Gomez. Mr. Gomez, you're charged with possession of a controlled substance, black tar, heroin, or fentanyl, crystal meth, possession of THC cartridge, petty theft, and drug paraphernalia. The argument to probable cause.
Yes, Judge. So on count 3, the cartridge, suspected to be a THC cartridge. This is sort of a more acute difference between, let me rephrase, Judge. That there's no way for these officers to know that this cartridge and the liquids contained therein is THC. There's no allegation that there's any odor of marijuana. There's no allegation that any of the officers sampled the device to ensure that it's not nicotine or CBD. What's more, Judge, so we don't even know that it's THC, and even if it was, there is non-scheduled THC cartridges available throughout Miami for purchase. So, Your Honor, I'd argue that there's no PCS to count 3.
Your Honor, we would argue when you look at the A-form in its totality, given all of the other drugs already in possession of the defendant, that it is reasonable and meets probable cause to believe that the black vape pen, it was in fact THC and wax.
There's a legal version of THC, correct?
I'm sorry.
If the court finds no probable cause on count 3, let's address the bond state.
The defendant doesn't have any convictions locally, however, his NCIC, so I've counted at least 4 different either burglaries or theft convictions. But given the allegations of the charges, we're okay with a standard bond.
Mr. Black.
Standard's fine, Judge.
Count 1 should be $2,500. Count 2 should be $2,500.
Count 3 with no PC,
Count
right?
3 was no PC.
And 4.
Count 4, the petite theft, should be $150. And counts 5 and 6 should be $500
each.
Each, yes, Your Honor.
He's released outright for count 3. There's a stay away order from Target store, also known as Target, at 1750 West 37th Street, Hialeah. Alam Rabasalas.
Ronald, this is the added charge on yesterday. You gave him pretrial alternate 1,000 on B242617.
Okay, so this is a new charge.
It was added.
Sir, this charge is, you charged with a domestic violence battery by strangulation and a simple battery.
And Your Honor, the state only finds that there's PC for the first battery charge, the battery by strangulation. In the four corners of the arrest form, there's no mention of another separate battery. So the state would stipulate to no PC and an ROR on count 2.
Well, it would be a release outright.
Yes.
That's what I learned yesterday from corrections. Corrections corrected me. Okay, I find probable cause for the felony battery.
So, Your Honor, pardon me, is there PC for count 1, given that the statute requires them to be household members or in a dating relationship? The A form states that they are not together and they don't reside together. So I think that this would be PC for simple battery.
For count 1 for the felony, I believe it would still be a battery by strangulation.
Is that a felony? Even if it's not domestic violence?
One moment to confirm, Your Honor.
If you could check 2A, I think that section specifies household members, those in dating relationships.
No, counsel, you're correct that the facts would not put either count within the domestic violence statute because both parties are ex-boyfriend, ex-girlfriend, and they no longer reside together. I think the only question is whether the count 1
strangulation is elevated.
The only way to elevate it is to allege that it's aggravated, and I don't think those facts are contained in the A form.
So, Your Honor, under the felony battery statute, I would argue, even though it is a non-domestic battery, I would still argue that it's a felony battery by strangulation, which the requirement for that is that it results in great bodily harm. And this victim did advise that she could not breathe and became unconscious as a result of being strangled.
Fortunately,
Your Honor, it's 784.041. It's isn't this that's domestic violence, but this is just felony battery.
Dating relationship qualifies, all right?
It does qualify, Your Honor, but the
It
arrest
says means a continuing and significant relationship of a romantic or intimate nature.
Your Honor, just the arrest form does say that they are ex-boyfriend, ex-girlfriend. So based on the arrest form alone, I would conclude that they're no longer dating. But the state would still argue that because of the fact that the victim literally became unconscious as a result of being strangled, this would still be a felony battery under 74.041, section 1B.
The court does find probable cause for felony battery. Choking someone to the point of unconsciousness, certainly arguably serious bodily injury. Very serious allegations. And what was the recommendation on bond?
We would request a $5,000 bond, Your Honor.
And for count 2, you admitted there's no PC, right?
That's correct.
What's your position on bond, Mr. Black?
Thank you, Judge. So Your Honor, on the misdemeanor petty theft, he was granted PTS and an alt bond, and corrections was successful in reaching his spouse, who was in the process of coming to TGK to pick him up when he received these charges.
That's not the victim in this case, is it?
It is not, Judge.
Okay.
At least that's my understanding that it's not.
Because that's a problem. Because they're asking for a stay away order. It's his wife, Jasmine Resevic?
That's not his wife, Judge.
Okay. The ex-girlfriend.
So Your Honor, we would be asking for PTS with the alt bond if we need to make it GPS, given the nature of the allegations. We can make it GPS total lockdown. He says he doesn't have $500 to go through a bail bondsman, sir.
The state would stipulate the GPS total lockdown with an alternate bond of $5,000.
Okay. So that would be released on a GPS bracelet level 3.
Level 1.
Level 1. Alternate bond 5,000. And a stay away order from Jasmine Resevic.
And Your Honor, for count 2?
That's a release outright, no PC. Matt, during the stay away order. Osmani Alcalde.
He's here, Judge.
Sir, you're charged with strong arm robbery, attempted strong arm robbery, and domestic violence battery. Court finds probable cause unless the defendant wants to make an argument.
Yes, Your Honor. One
She's
moment.
not there.
Oh, no, we stand mute on PC, Judge.
Okay. What's your position on bond state?
We asked for the standard bond, Your Honor. So for count 1, that would be 5,000. For count 2, that would be 1,000.
For attempted strong arm is 5,000. Is it violence or is it 2,500?
But I'm there by myself. Okay.
Attempt is a 3rd-degree felony. It would be 2,500. That's not correct.
And 1,000 for the battery?
And 1,000 for battery, yes, Your Honor.
Okay.
Your Honor, defense wishes to make an argument with respect to bond.
All right.
So, Your Honor, Mr. Alcade has represented to me that the alleged victim actually does not live at the location. He does have a son who he's responsible for, who does live at the location. He doesn't have extensive priors. In fact, I'm only seeing one prior arrest. The facts, while concerning, I'm not saying they're not concerning, are not egregious. It seemed to be an emotional situation in which he wished to rip a present off the alleged victim's neck. I'm not saying it's not concerning, but it's not egregious. So, Your Honor, I'd ask for PTS with alt bonds, and if you're not willing to consider that, GPS roaming so he can continue to be at home with his son.
The A form alleges their boyfriend and girlfriend who lived together as a family. You're saying that's not the case? Mr. Black, that's not the case?
It's not a.
So Your Honor, so Your Honor, no, I can't make a representation that that's the case. I'm sorry. So I withdraw that representation. I'm getting conflicting reports here. So standard bond is fine for now, Judge. We can revisit it with the trial court.
Very well.
Thank you.
There's also going to be a stay away order. If he does bond out, he's going to have to find another place to live if he is in fact living with Ms. Lopez.
And that was 2,500 count one, 1,000 count two.
Correct. Stay away order. For DV injunctions, which I handle, they don't have to be living together anymore. Dave, do you know that?
Yes.
I think the court just handles all injunction cases for the administrative order.
Carlos Alberto Rodriguez Cardenas, sir.
He's here, Judge.
You're charged with tampering with evidence, resisting arrest without violence, and petty theft with a previous conviction. The list incident occurred at Marshall's. Officer said he chased you and allegedly you threw stolen merchandise on the floor.
And Your Honor, just a heads up, defense will have some PC arguments. And my apologies, Judge, I didn't realize until now he'll need the services of an interpreter.
Interpreter present.
Okay, let's push the rewind button.
Thank you.
Mr. Cardenas Rodriguez is charged with tampering with physical evidence, resisting an officer without violence, and petty theft with prior convictions.
Señor, usted tiene un cargo por manipulación o alteración de pruebas físicas. También tiene un cargo por resistencia a la policía sin violencia y un cargo por hurto de menor cuantía con condenas anteriores.
What's your argument on BC, Mr. Black?
Yes, Judge, thank you. As to count one, tampering, the statute requires the altering, destroying, concealing of items in order to them impair their verity and availability, Judge. So tossing the items so as to make them visible to police and readily accessible to the police, I don't think would count as tampering, Judge. There's no attempt to destroy them or conceal them, rather just drop them as he's running. That's not tampering. He's making them more available to the police officers that are in pursuit.
Alteración del orden, perdón, alteración o manipulación de pruebas físicas bajo el estatuto requiere que haya destrucción o el hecho de esconder estas pruebas, el hecho de que tirarlas enfrente de la policía, eso no sería lo que constituiría destruir o esconder. Ir corriendo haría que, y tirarlas haría que la policía las encuentre más fácil.
State.
Your Honor, so it is the case with the hair clippers that it looks like he just tossed them into the parking lot. With the backpack and the socks, it looks like it's a different story. The arrest form says that he hid them in the bushes. So it seems as though he was trying to conceal them.
Su señoría, con respecto a el dispositivo que había para el pelo, eso parece que sí es diferente a el maletín o al morral y las medias que las trató de esconder tras los arbustos. Entonces ahí sí parecería que estaría tratando de manipular o esconder.
Judge, I would just read you from the A form. It says, hold on, sir, hold on, sir. He said,
Un momento, señor.
he threw a set of hair clippers into the parking lot near the 800 block of 17th Street, comma, a pair of socks into the bushes. So in other words, he threw the socks into the bushes. It doesn't say that he hid the items in the bushes. He was throwing items as the police officers were behind him. He didn't know it was gonna land in the bushes.
Aquí dice que estaba tirando las medias en los arbustos, no dice nada de que estuviera escondiendo y dice que tiró en el estacionamiento los ganchos para el pelo, eso fue en la cuadra 800 de la calle 17, no dice nada de que estuviera escondiendo.
So it does seem to be a weak allegation, State. I'm finding no PC on count 1, but probable cause for the other 2. What is the?
I apologize, Judge. I was going to make arguments as to count 2.
Okay, one moment, let me interpret up to now. Entonces el juez ha dicho que no haya que existe motivo fundado por el cargo número 1, pero en cuanto a los otros 2 cargos, el abogado tiene sus alegatos.
Yes.
Your Honor, the A form does not contain allegations of any lawful orders to stop, no allegations of the officers IDing themselves as police officers, no allegations that they were wearing police insignia.
Su señoría, en el affidavit de arresto no se dice que hubo ninguna orden de detenerse, tampoco dice en el affidavit de arresto, no dice que los policías se hayan identificado como policías ni que tuvieran algún tipo de escarapela o insignia que indique que son policías.
Sí.
The state has no argument to that. The state would agree there's no PC for.
So there's no PC on count 1, no PC count 2. That leaves us with PC for petty theft. But does it say he has prior convictions?
Bien, entonces el juez ha dicho que sí, no existe motivo fundado por el cargo número 1 o el cargo número 2. Eso nos lleva al cargo número 3 de hurto de menor cuantía. Pero
Petty theft prior convictions.
mirando a ver si dice que existen condenas anteriores.
The state would be requesting the standard $500 bond.
La fiscalía estaría solicitando la fianza estándar de $500 por el cargo número 3.
Prior history. Thank you. You have an open case?
He does have an open misdemeanor case, Your Honor.
Another petty theft?
Sorry, State.
$500 in this case. He's released outright counts 1 and 2, count 3, $500.
En libertad directa, cargo número 1 y 2, y por el cargo número 3 tiene una fianza de $500.
Yes, Your Honor. There's a in the marshals at Winston Lanes.
And sir, you to stay away from the marshals on Miami Beach on Lincoln Lane.
Señor, y usted tiene que mantenerse alejado del Marshalls que queda en Miami Beach en Lincoln Lane. Ya está.
Anthony Monterrubio. Is this Mr. Monterrubio? He's charged with grand theft of a firearm and carrying concealed firearm. Oh, are there 2 cases? No, I just in my
And
Twitter, I picked up 2.
defense will have PC arguments, Judge.
Okay, so it alleges that he had possession of a firearm that was reported stolen on 11/21. What is your argument, Mr. Black?
So Your Honor, our argument is as to count 2, concealed carry. So Your Honor, the A form alleges that the officer could observe the firearm. That sounds like open carry to me, Judge, not concealed carry. He could see it.
What he said he could see was the magazine, which is not the firearm itself. Is that correct, State? The magazine being the packet that carries the bullets.
That is correct, Your Honor.
So I think you're confusing the gun with the magazine, which are not.
Okay, understood, Judge, understood.
Finding probable cause, let's address his bond.
The defendant does not have any priors. We're asking for standard bond, which for count 1 would be $2,500. For count 2 would be $500.
Yes, Mr. Black, what do you say?
Yes, Judge, thank you.
Standard bond. 2,500 and 1,000, right?
500, Your Honor.
500.
We'll need the interpreter, Judge.
Your Honor, that was 2,500 count 1 and 500 count 2.
Yes, ma'am.
Thank you.
Brianne Matut, we need the interpreter.
Yes, Judge.
Mr. Matut, you're charged with possession of cocaine, tampering with evidence, and resisting an officer without violence.
Señor Matute, usted se le acusa de tenencia de cocaína, manipulación de pruebas y resistencia a la policía sin violencia.
What's the resisting, State?
Your Honor, the state would argue that there is probable cause for the cocaine possession and evidence tampering charges, but there is not PC for the resisting without violence charge.
Su señoría, la fiscalía dice que sí existe motivo fundado por la tenencia de cocaína y la manipulación o alteración de pruebas, pero no existe motivo fundado por el cargo de resistencia a la policía sin violencia.
Mr. Black.
So, Your Honor, I would agree with State that there's no PC for count 3. I would also argue that there's no PC for count 2. Again, that statute is meant to criminalize the altering, destroying, concealing of evidence. In this case, dropping it right in front of their face. He's failing to damage it. He's failing to hide it. In fact, just the opposite. He's making it readily accessible and visible to them.
Su señoría, estoy de acuerdo con la fiscalía que no existe motivo fundado en cuanto al cargo número 3, pero en cuanto al cargo número 2, es lo mismo que decía anteriormente. El estatuto dicta que tendría que alterar, destruir o esconder pruebas para que eso sea manipulación o alteración, y en este caso simplemente se tiran donde la policía las puede encontrar más fácil.
All right, the court agrees with the defense, finds no probable cause, counts 2 or 3. There is probable cause for the felony possession of cocaine. Does he qualify for pretrial release?
El juez dice que sí está de acuerdo, no existe motivo fundado por cargo número 2 y 3. Por el cargo número 1 sí existe motivo fundado, ese es el cargo de tenencia de cocaína. Él califica para el programa de ser liberado bajo un programa.
Corrections is telling me he has immigration hold.
Los del Departamento de Correccional me dicen que él tiene una detención de inmigración.
Is that correct, Corrections?
That's correct, Judge.
All right, I'm just going to set the standard bond on this case is $2,500 then.
I'm sorry, Judge, $2,500?
Yes, ma'am.
Thank you. Entonces voy a fijarle la fianza estándar que es de $2,500 y tiene una detención de inmigración.
So that's a release outright on counts 2 and 3 only.
Libertad directa bajo el cargo número 2 y 3.
Terrence Slocum. Mr. Slocum, you're charged with possession of ecstasy, possession of cocaine with intent to sell, possession of cannabis with intent to sell, possession of cannabis. I'm sorry, it's 3 counts of possession with intent to sell cocaine, and also unlawful use of a communications device. Court is going to look at the affidavit. Probable cause, is there anything, Mr. Black, you want to say?
Not as probable cause, Judge, just to the bond.
Your Honor, it would be moved to hold the defendant under statute 907.041.
Yeah.
I'm sorry, Judge, we're having a bad connection over here. Can the prosecutor repeat what they said?
I filed a motion for pretrial detention. What is the basis for the motion?
The first count, trafficking of the ecstasy, is considered a dangerous crime under Florida statute 907.0415A.
Sorry, counsel, can you repeat the statute number of the pretrial detention statute?
It's 907.041 subsection 5A.
And the hearing would take place when?
It has to take place within 5 business days, or just 5 days.
It'll take place in front of the division judge, right?
Correct, Your Honor.
Okay. So it does appear to meet one of the qualifying offenses because it is trafficking in a controlled substance. I'm going to grant the motion for pretrial detention pending a hearing to be set in front of the division judge tomorrow. Here in front of the division judge tomorrow, and they'll address your bond status today.
So that's no bonds, counts 1 through 7?
That's correct. Oh, because it's the trafficking? No bond on the trafficking. It'll be standard bond for. We're gonna have to figure it out. 2 through 5 is the sale of cocaine.
There is no standard bond for second-degree felonies. We would be
Not
asking
for sale of cocaine.
the sale of cocaine.
Would it be 5,000? Clerk is nodding her head yes.
That's what everyone is indicating. Yes, Your Honor.
Okay, so count 2, 3, and 4, it's $5,000 each. Count 5 is 2,500. Count 6 and 2,500. Count 7. This it's filed Oh, I need to sign this, right?
Correct, Your Honor.
Your Honor, can I bring something to your attention?
You may.
So, under subsection 5, I'm not sure which point under subsection 5 council is using to justify pretrial detention. I'm seeing subsection 24, trafficking in any controlled substance described in 893.135(1)(c)(4). Mr. Slocum is charged under 893.135(1)(k)(1). So would that qualify as an offense for which he can be held no bond under that statute?
It says any controlled substance. And by the way, your order is, this is a template order which doesn't apply to this case. Have you read it?
Okay.
It says it should be more specific as to a trafficking offense, because if you're not seeking a pretrial detention on a capital life felony or felony of the first degree, right?
Correct, Your Honor.
All right, so let's go to the statute. Statute references 893.135(1). C4.
I don't think it counts. No, doesn't count. Oh, sorry. I thought it was muted. Sorry about that.
Doesn't it have to be coke? It looks like it has to be cocaine. No?
It looks like it has to be alfentanil, carfentanil, fentanyl, sufentanil, fentanyl derivative, morphine. Yeah, I don't think. Yeah, I don't think MDMA or ecstasy is captured by the statutory language.
Hydrocodone. Oxycodone. Fentanyl. Codeine. Can you show me where it says we're talking about the drug in question here?
Your Honor, I am looking for it and I cannot find it, so we would be agreeing with defense. I'll ask or all of the counsel, we would ask for a Nebula hold to ensure that the money used to bond out is not money that's been acquired through the sale of drugs.
Right.
We haven't done it yet.
So we'll cancel the pretrial detention. Count one, what is the standard bond? Motion for pretrial detention is denied.
Understood, Your Honor.
Clerk,
5,000, Your Honor.
clerk has pulled a yellow card. You pulled a yellow card on this hearing. 5,000?
5,000, Your Honor.
All right, so Mr. Black, the state agrees with your argument. Bond for count one at $5,000.
Your Honor, I hate to interrupt you. May I make a brief bond argument? So, Your Honor, before we went down the road of PTD, I was going to ask Your Honor for GPS with alt bond or even an alt no bond hold if he violates GPS. He can't afford any of this bond anyway, so a Nebula hold would be pointless. What's more, he's got no convictions and he has kids at home. And so I think GPS accounts for the fact that he is entitled to a non-monetary bond. He doesn't have convictions.
Do you have an address? Let me pull the other one. Corrections has pointed out to me that his address on the A form is San Francisco, California.
He's saying that's his ID, but you do have an address in Florida? Okay.
ID.
And your kids are there?
My kids are back and forth.
Your kids are back and forth? Okay. He's saying that's the ID on his, excuse me, that's the address on his ID. Are you able to give him your address here in Miami?
Yeah, 3200 Collins Avenue.
Sorry, counsel, I'm gonna stick with the standard bond and there's gonna
judge. Understood.
Be a hold because of the multiple allegations, not just one sale, but they have alleged, I think, 3 different incidences of sales. So.
Okay, Judge.
Garrett Keon Adams. Sir, you're charged with sale, delivery, or possession with intent to sell cocaine. Says the officer did a pat-down search and found a baggie with 8 small clear baggies of a white powdery substance of suspect cocaine.
Your Honor, I'm really starting to sound like the public defender's office, but I do not. Being mentioned at the arrest form is that detectives on the scene concluded that the defendant had intent to distribute the narcotics, but it does not say how they reached that conclusion.
With the simple possession. So Mr. Black, they're conceding there's only PC for simple possession.
Thank you, State.
He has ties to the community. Any prior?
Your Honor, he's representing to me no prior convictions of any kind. And so, Your Honor, we'd be asking for ROR with it, just ROR in this case, Judge.
PC for simple possession of cocaine. What was the state's position?
Your Honor, the state would, it was greater than 10 grams of cocaine. So the state, and it's still a 3rd-degree felony at least. So the state would be asking for.
What about pretrial services? He would qualify?
We would do pretrial services with an alternate bond of 2,000.
Okay, that's what the court will do is pretrial services, alternate bond 2,000. What is this? Sorry, as the day goes on, I get short. Guess we're not going to meet my goal. Keith Lamar Jackson. Is this Mr. Jackson?
Yes, this is Mr. Jackson. He's here.
Okay, sir, you're charged with possession of burglary tools, dealing in stolen property, possession, intent to sell or deliver cannabis, armed possession, loitering, and prowling. Anything else? Yes, possession of drug paraphernalia. The officer said he made a consensual stop with the defendant. He had asked if he had any guns or weapons. He said he had a knife, a black holding knife. Said he had a crack pipe with a little bud. So in his backpack, he had a hammer, a hat, grooming system, a dog kit.
We got some PC arguments, Judge.
I understand. Maybe the state will agree because they have been very agreeable today.
They've been very amenable, and I appreciate it. As to count one,
I was going to make the argument, not the argument, but I was going to ask the state, where's the possession of burglary tools? Got a hammer in a backpack.
That is correct, Your
He's got a hat and a grooming system. I don't, maybe, is it common for burglars to be well groomed? Is that what the argument of the officers?
I would argue hammer in conjunction with the 3.5-inch folding knife.
I find no probable cause for possession of burglary tools. What about the next case, count for dealing in or conspiring to deal in stolen property? Even if you assume that the property was stolen, how is that the intent to deal in stolen property? Just possession of stolen property.
I would agree there's no PC for count three.
Okay, count two, no PC. Possess intent to sell marijuana. How much marijuana are we talking about?
We would ask that you find PC for simple possession.
What is the loitering and prowling?
State would concede there's no PC for loitering and prowling.
You see that, Mr. Black? Oh.
One big bag.
So just to clarify, no PC for 1, 2, 1, 2, 4.
3.
I'm sorry, we're getting a lot of feedback over here. I'm having a hard time hearing you guys.
There's no PC on count 1. No PC count 2. Count 3. The court finds PC for simple possession of marijuana. What is the drug there, Fenonia? A pipe?
The pipe, Your Honor.
Okay. The court finds for misdemeanor possession of marijuana and misdemeanor possession of. Where does that leave us with bond? What is that? 500?
500 for the paraphernalia. I believe 500 for the possession as well.
So that's 500 for 3 and 5?
That's right.
So, Your Honor, I would ask, given some of the allegations here, but we would ask for an ROR in this case. He's not going to be able to afford anything. And so, Your Honor, we've got no PC for 4 of the 5 allegations. And so, you know, he's not going to be able to find a bondsperson to put up $100 for a $1,000 bond. If we give him a date certain, he can get back to court. I'm looking at the priors here. I don't see anything that's. Excuse me one moment.
Do you have his prior state?
I do, Your Honor.
So we do, is this a,
Is one open case for
say that, Judge?
paraphernalia report?
Yeah.
Judge, can we set this case on a date certain on the same date?
The open case has a future hearing date of 3/12.
That's history.
It is the 9th today, Your Honor.
Oh, I'm sorry. The loss of an hour's sleep.
It's okay.
So how would that work if I send him to the homeless calendar and he has another case in another division?
He'd still have the dates for that case, Judge. He just has one on homeless calendar.
So they'd be in two separate divisions.
Sounds like it. Since we only have misdemeanors left, it's something we can do.
You're gonna give him an ROR, and is it the 8th or the 9th?
Who are we on, Jackson?
We're on Mr. Jackson. Well, there's no PC on all of the felonies. So there's no PC, count 1, release outright. No PC, count 2, release outright. Count 3, PC for possession of marijuana only, 5, it would be an ROR. Count 4, loitering and prowling, no PC, release outright. ROR, count 5, drug paraphernalia.
So, Your Honor, on counts 3 and 5 is ROR.
Yes, ma'am. We're gonna direct him to report to the homeless calendar. I'm just trying to find the date. Yes, it says homeless on the arrest affidavit.
And so, Your Honor, that's April 8th?
April 8th. Victor Riveron.
Present.
Sir, you're charged with battery, strangulation, and assault.
Sorry, corrections. What number is this?
Number 50 on the calendar.
Thank you.
Arguments, probable.
Stand mute, Judge.
All right, the court finds probable cause on both counts. State, what's your position on custody? Release conditions?
The defendant does not have any priors, however, given the allegations in the arrest form, we're asking for an $8,000 bond for count 1 and a $1,000 bond for count 2.
Defendant?
Asking for standard, Judge.
Standard?
Standard for count 1 would be 5,000. Count 2.
That's the assault?
The assault,
Is it 500?
I believe would be 500, yes.
Okay. So your bond is $5,000 at count 1 and $500 on count 2. I'm entering a stay away order. You're having no contact with the alleged victim in this case. Don't know if we have her name here. This is by initials TP. They do not live together, correct?
I do not believe so, Your Honor.
Jonica Danielle Zamudia.
On his traffic, you gave him a bond of $150.
Sir, you have felony charges of grand theft.
I'm sorry, Judge, you'll need an interpreter.
Interpreter present.
He has felony charges of grand theft, fleeing and eluding a police officer, and also misdemeanor resisting without violence.
Usted tiene un cargo por hurto de mayor cuantía, otro cargo por huir y eludir de la policía y un cargo de un delito menor por resistencia a la policía sin violencia.
Your Honor, would you like the state to say which counts they think there is PC for and which counts they think there may not be PC for?
I'm always amenable to hear the state conceding no probable cause.
Well, Your Honor, for the grand theft count, there is a victim listed in the arrest form, but on the four corners of the narrative and the arrest affidavit, the only thing that could give rise to this charge is basically that the defendant changed his story about where the vehicle came from, but the state does not find that that gives rise to probable cause for grand theft.
Right, so the state conceded probable cause on count 1.
That's correct.
La fiscalía dice que en cuanto al cargo número 1 de hurto de mayor cuantía, en la víctima, en el affidavit de arresto, en el formulario, dice un nombre de una víctima, pero en la narrativa no lo dice. Entonces, básicamente, lo único que daría que exista motivo fundado sería que el acusado cambió su versión de dónde venía el vehículo. So, Judge, I'm sorry, I couldn't hear if they did or they did not.
They conceded no probable cause for the grand theft.
Entonces, concedió la fiscalía en cuanto a motivo fundado por el hurto de mayor cuantía.
Defense, any arguments?
Stipulating to the state's finding.
So you agree as to the other counts there's probable cause?
La defensa está de acuerdo con la fiscalía que no existe motivo fundado y en cuanto a los otros cargos, ¿están de acuerdo que existe motivo fundado?
We would stand mute, Judge.
So I find probable cause for count 2, the fleeing and eluding, and count 3, the resisting.
Entonces el juez ha dicho que haya que sí existe motivo fundado por el cargo 2 y 3, que el cargo 2 es huir y eludir de la policía y el 3 es el de resistencia a la policía sin violencia.
What is the bond on count 2? 500?
That's correct, Your Honor.
And for 3,
It would be 500, Your Honor.
any argument as the bond?
I don't know if the state has priors for Mr. Zamudia, but he may qualify for PTS if the interpreter can ask him if this 211 York Street is his permanent address.
Ok, vamos. Entonces el juez ha dicho que la fianza por el cargo número 2 es de 500, cargo número 3 es de $500. Están averiguando si podría calificar para servicios previos al juicio. La dirección que queda en la 211 York Street es su dirección. ¿Sí?
No.
¿No es su dirección?
He hasn't been here long enough.
Yo le dije que mi dirección estaba en el teléfono porque yo estoy recién mudado.
My address is on my phone because I just recently moved.
Yes, so the correction says he's not long in here. Man, my tongue tied. He hasn't been here long enough to qualify for pretrial services, so.
Bien, los del Departamento Correccional dicen que no lleva aquí suficiente tiempo como para calificar para servicios previos al juicio.
I'm gonna set the standard bond. So count 1, he's released because there's no PC. Count 2, $2,500. Count 3, $500.
Entonces las fianzas son las siguientes. Por el primer cargo queda liberado directamente porque no existía motivo fundado. Cargo número 2 son $2,500 y cargo número 3 son $500.
He already has a bond on the traffic offense.
Y tiene fianza con respecto al delito que tenía de tránsito.
Michael Alvarez.
Yes. No.
You're good, you're good.
Un momento.
No. Yeah.
Mr. Alvarez, does he need the interpreter?
¿Necesita intérprete?
Yes.
You're charged with possession of crystal meth, tampering with evidence, and carrying a weapon.
A usted se le acusa de tenencia de metanfetamina cristal, también de manipulación o alteración de pruebas y de portar un arma.
The court finds probable cause.
El juez halla que sí existe motivo fundado.
Your Honor, I have some PC arguments.
Tengo alegatos.
All right.
As to count 2, again, tossing the paper on the street. He's not altering, destroying, or concealing it. In fact, he's doing the opposite. He's making it visible and accessible to the officers. So that's count 2. As to count 3, open carry of a weapon. So 790.053 precludes the open carrying of firearms or electric weapons, not knives. So there's no PC for this count.
Su señoría, en cuanto al cargo número 2, lo que se había dicho anteriormente, tirar o los papeles no constituye alterar, destruir o esconder. Esto, de lo contrario, lo que hace es que sea más visible para la policía. En cuanto al cargo número 3, portar armas ocultas, en el estatuto 790.053 habla de portar armas de fuego, pero no habla nada que tenga que ver con cuchillos.
Let's go. Esteemed colleague, Mr. Lyle or Ms. Coughlin? Who would like to take this one?
I have this one, Your Honor.
All right.
I agree under the statute cited that statute specifically references firearms and the defendant did not have a firearm, he had a knife.
All right.
La Fiscalía dice que está de acuerdo que bajo ese estatuto específicamente que fue mencionado, habla de armas de fuego y el acusado no tenía armas de fuego, era un cuchillo.
What about the tampering charge?
Y el cargo de manipulación.
As for the tampering charge, I would argue he was trying to conceal it. He knew he was going to get pat down and threw it on the street in hopes the officers would not find it.
Con respecto al cargo de alteración o manipulación de pruebas, entonces yo alegaría que estaba tratando de esconderlo al saber que lo iban a requisar. Él tiró para tratar de esconder y que la policía no lo viera.
I would just argue, Judge, that part when the prosecutor said in the hopes of not finding it, that there's no allegation contained in the four corners of the A form that he was intending to conceal, destroy, or alter, which is what the statute prescribes. In fact, he did the opposite. He threw it on the street in front of the officer, and the officer wrote, "Without losing sight of the paper ball, I retrieved it."
Su señoría, específicamente lo que dice en las alegaciones, lo que dice en el estatuto es que él, perdón, no en el estatuto, sino en el affidavit de arresto, es que el oficial vio cuando él lo tiró y nunca lo perdió de vista. O sea que en ningún momento estaba tratando de esconder, alterar o destruir.
The court finds there's probable cause for count 1 and set the bond at $2,500.
El juez ha dicho que haya que sí existe motivo fundado por el cargo número 1, fija la fianza en $2,500.
The court finds no probable cause on counts 2 and 3 and will release outright the defendant.
Y el juez ha dicho que no encuentra que exista motivo fundado por el cargo 2 o 3 y por esos dos cargos lo deja salir directamente.
However, he has a felony hold for case number F253015.
Sin embargo, tiene una detención por un delito mayor que es el caso F253015.
Okay, so.
James Howard.
Howard.
Mr. Howard.
How you doing, sir? Mr. Howard, you're charged with possession of cocaine, tampering with evidence, and purchase or possession with intent to purchase crack cocaine. So the officer observed you smoking from a glass pipe. Black male walked up to you, handed him an unknown amount of money. The co-defendant went back. You also, as the defendant was observed putting the suspect rock in his mouth and swallowing it. There were any arguments to PC?
I'm from the state, Your Honor.
From the defense?
I'm sorry, Judge, stand mute to PC.
All right, I find probable cause. So count 1.
Judge, my apologies. We'd just be asking for tap, given that he's not going to be able to afford to bond out.
History. State. Court's gonna just set standard bond. Could you say, tell me what they are for counts 1, 2, and 3?
So, Your Honor, the standard bond for count 1 is $2,500, as well as for count 2.
Count 3.
For count 3, I believe there's currently no standard bond, but the state would ask for $1,000, Your Honor.
$1,000. Did you get that corrections?
So that was
2,500, 2,500, 1,000.
Yes, ma'am.
Thank you.
So if somebody come up with six.
Miguel Alexander Alvarez Fuentes.
We'll need an interpreter for Mr. Alvarez Fuentes.
Interpreter present.
Sir, you're charged with grand theft of the vehicle, possession of drug paraphernalia, and driving the license suspended. Did we already do the TWLS?
Your Honor, you took care of all the traffic.
Okay.
Señora, usted se le acusa de hurto de mayor cuantía de un vehículo, tenencia de parafernalia para el uso de drogas y manejar con la licencia suspendida.
What's the drug paraphernalia?
Drug paraphernalia is a clear glass pipe containing a white residue suspected meth.
¿Cuál es la parafernalia para el uso de drogas? El parafernalia para el uso de drogas es una pipa transparente que tenía incluida un residuo blanco.
The court finds probable cause.
UTPC.
Hay que si existe motivo fundado.
So it'd be $2,500 and $500. Is that right, Steve?
That is correct, Your Honor.
$2,500 count one, $500 count two.
Sería $2,500 cargo número 1, $500 de fianza cargo número 2.
Matthew Page Thomas. Matthew Page Thomas. Sir, you're charged with possession of cocaine with intent to sell within 1,000 feet of a church or convenience store, possession of cocaine more than 21 grams, tampering with evidence, resisting, and that was all. Court finds a probable cause. What is the bond for the first count?
Your Honor, I believe the standard bond for that count is to be set, but given that it's a first degree felony, the state would be asking for $5,000.
Your Honor, would you be amenable to PTS for all?
No, sir. Well, let me ask, does he have a criminal history?
He does have a criminal history, Your Honor, and he has several convictions for drug possession with intent to distribute, the same kind of thing as the arrest in this case.
Okay, so for count one, your request for pretrial services denied. Count one, 5,000. Count two
would be 2,500, Your Honor.
2,500,
as would count three.
and 2,500 on count three.
And $500, Your Honor, for count.
Count four, $500.
That may have already been set.
No.
No, I apologize.
Kenyon Lamont Smith. Mr. Smith, you're charged with possession of cannabis more than 20 grams and smoking cannabis. Finds probable cause.
So, Your Honor, we would make the same PC argument with respect to the cannabis in this case as we've made in the past. There's no way to determine whether it's scheduled cannabis.
The officer said by his experience, he could tell it was, so I find probable cause. Count one,
$2,500, Your Honor.
does he have a prior history?
He does not have any prior history.
No prior history? What's your position, Mr. Black, on custody release?
Given the allegations, Judge, we'd ask for ROR.
Would he qualify for pre-trial? He's not local. His address is Milwaukee, Wisconsin.
That's accurate, Judge.
He doesn't have a local address?
He does not. He was a visiting judge.
Came up here for a birthday shoot.
Yeah.
If I set the bond at $1,000, can he make it?
You can do that, Judge.
Count one, $1,000 bond. I'll give him an ROR on count two. Joseph Petit June. Already passed yesterday's. I don't know how that's possible. Is this Petit June? Is this Mr. Petit June?
Yes, Judge.
Okay, sir, you're charged with possession with intent to sell cocaine, possession with intent to sell marijuana within 1,000 feet of the school, possession of controlled substance, MDMA, resisting an officer without violence, and that's all. Nine multicolored baggies, cannabis. $64 in cash. Narcotics stitched inside the defendant's waistband, including 8 small clear baggies of white powdered substance consistent with cocaine. Does it identify it at the school?
It does not, Your Honor.
Okay. You could have jumped in there.
Your Honor, I was searching for it just as hard as you were. But I do think the state will probably have to stipulate that there is no PC for the first count.
for possession with intent to sell within 1,000 feet of the school.
However,
So that is the aggravating factor.
yes, Your Honor.
That is the same for the cannabis with intent to sell within 1,000 feet of the school.
That's correct, Your Honor.
And where's the MDMA allegation?
It's on the third page of the arrest affidavit, Your Honor, toward the bottom. It says that one clear small plastic baggie containing 2 suspected MDMA pills.
Anything from you, Mr. Black?
So, Your Honor, stipulate to state's findings on PC, and would also argue that count 4, I don't see any allegations for lawful commands being ignored. I don't see allegations of the police identifying themselves or any police insignia.
No, on paragraph, I'm sorry, page 3, it does say the officer called out to him and he took off running on foot.
That could be construed as a consensual encounter, Judge.
So no probable cause for the 1,000 feet aggravator.
That's correct, Your Honor. The state's position would be that there is probable cause for possession of cocaine with intent to sell, which is a 3rd-degree felony.
Okay, so
I'm so sorry. Just to clarify for 1 and 2, no PC for the aggravating factor of within school zones, but rather with just intent to sell.
that's correct. So that would drop the first one to a felony 2, and that's 5,000.
Yeah, I believe that's correct, Your Honor.
Okay, $5,000 on count 1. Count 2 is $2,500. Is that right?
I also believe that's correct, Your Honor.
Count 3 is also $2,500. Count 4 resisting is 500.
Yes, Your Honor.
Count 5, no, count 5. All right. We have
Count
500, 2,500, and 500.
So, Your Honor, now that we've fleshed out where there's PC and what the standard bonds are, we'd ask you to give him tap, Judge, with the alt bonds of all the standard bonds.
Do you have his prior history?
Yes, Your Honor. Give us a second. The prior history is not clear.
I'm seeing multiple pages, Mr. Black. There's a lot of no actions.
I believe they are front and back, Your Honor.
Okay. Given his history, which includes a conviction for the prior offense, I'm not going to give him tap. So the bond remains the same. Roberto Pulido.
You bond out, Your Honor.
Bonded out? David Geddes? Is this Mr. Geddes? Mr. Geddes is charged
This is he, Judge, sorry.
petty theft with 2 prior convictions. Is alleged that he stole from the I don't think it says the store. Masons. The court finds probable cause. Records check does reveal prior convictions. What's your position on bond state?
Your Honor, the defendant in this case has significantly more than 2 prior petty theft convictions. So because of that, instead of the standard bond, we'd be asking for an elevated bond of $3,500.
Would state accept a plea of adjudication CTS?
Not at this time.
Well, the court can make the offer if the defendant is willing to take it. Client willing to take CTS?
He's making that offer to you, Judge.
But this is a 3rd-degree felony. I'm sorry, Mr. Black, I'm not going to do that on a third-degree felony. But it will. It says, is he homeless?
Yes, Judge.
Can I see his record state?
Yes.
Your Honor, he would offer 60 days in order to close the case.
I'm guilty, Your Honor.
I'm sorry, I understand, but since this is a felony, we're going to send you to his division. Your division judge can make that decision. And you'll be in front of him shortly. Frankly, I don't want to be responsible for you pleading to a felony at the arraignment. All right?
Sorry, Your Honor, what was the bond amount?
Bond is,
The state requested $3,500, Your Honor, given the priors.
I think 3,500 is a bit much. I'm going to set the bond at $1,000. Control Lamar Parish.
I don't feel any bond, F24-15419 Alpha.
Mr. Parrish, you're charged with petty theft with 2 prior convictions, theft from the West Marine store, or do they have reference to the prior convictions in the A form?
They do not, Your Honor.
All right, so it's simple petty theft.
Correct, Your Honor.
All right, the court only finds PC for petty theft. What's your position on his bond status?
We would just ask for standard bond, Your Honor.
Mr. Black?
Your Honor, does corrections see any holds?
Oh, yes, I think they said he did. Corrections, is that right? He has a felony hold.
Okay, Judge, standard bond is fine.
Standard bond for petty theft is 250 or 500.
I think that doesn't end.
No, from here.
250,
I believe it's 250, Your Honor.
250 going once, twice. All right. Sir, you also to stay away from the West Marine Store in Pinecrest.
50, Your Honor.
250. Didn't I say 250? Yes.
Correct.
250 plus the felony hold.
So, Your Honor, I don't know if the state is willing to check. Mr. Parrish says he's positive that last week on the felony case, it was a KNP. Are you seeing that reflected anywhere?
The clerk's going to check now.
He just is not showing that, Your Honor.
Okay, then.
He says the state null prost. No, it's not in the system, sir.
Okay.
Irving Johnson. Sir Johnson, you're charged with petty theft of ribs from Whole Foods. Court finds probable cause. Well, it does say prior. It says prior robbery convictions which can be used as theft convictions. Is that correct, State?
That's correct, Your Honor. He's also out on a felony hold. I don't know if corrections are.
Corrections, no, they haven't told me. Does he have a felony hold?
F25. 3152, Your Honor.
3152. Yes. Felony hold. And the bond on this case would be $2,500.
That's correct.
Bond is set at $2,500. Albert Rodriguez. We have two cases for Mr. Rodriguez. The first case is grand theft or conspiracy to commit grand theft of a vehicle fleeing and eluding the police, no valid driver's license. We can see where the conspiracy point comes from, but he admits to driving a car that he knew was stolen, so that's grand theft. So I find probable cause. I think he was before me this morning on the traffic calendar. No?
Your Honor, you gave him a bond of $150.
So in this case, I'll set the bond at $2,500 on count one and $2,500 count two.
Your Honor, could I be heard on bond?
You can.
Given that he's a young man and he does not have an extensive record and he's representing to me that he doesn't have the money to bond out, I'd ask you to consider GPS total lockdown with an alt bond. He does say that he attends school online, so he could be home doing that instead of sitting in jail.
Well, the problem I have, counsel, is the next case, aggravated battery on a law enforcement officer. So,
Judge, I would only argue that if he's able to get family to pay for the bond, he'd be in a less restrictive situation than if we put him on GPS total lockdown.
I'm sorry, but because this the serious charge, he has 2 cases, including the aggravated battery on a police officer, which is a first-degree felony, right, State?
It is, Your Honor.
I'm not going to do that. I'm just gonna set it at standard bond in this case. I also find probable cause on the second case. And bond on that would be 5,000, State? 10?
So, Your Honor, could I just have one moment on the battery to pull up the statute?
An aggravated battery, you need to look at the statute?
Yes, Judge, just 1 second, thank you. Okay, Judge, nothing more, thank you.
Probable cause $10,000 bond. Richard Alphonse.
Your Honor, he's out on felony bond F 2322796.
Sir, you're charged with battery by strangulation and misdemeanor battery.
Your Honor, I think there's PC for domestic violence battery by strangulation. The arrest form does say that the parties were in a relationship. I do not think there's PC for the M1 battery because I don't see any evidence of a second battery.
So you're saying probable cause for domestic violence battery or what do you, I don't understand you.
I did, the state did represent that, Your Honor, but because even though the parties were dating, because the arrest form doesn't say they were residing together, it would not be domestic violence battery. The state would say there's probable cause for count 1 as it is, and there's not probable cause for count 2.
Okay. Court finds probable cause for count 1, no PC for count 2. And the standard bond would be 2,500. Is that correct?
Your Honor, it would be 5,000 for count 1. As well as a felony hold.
All right, setting bond at $5,000 count 1. On count 2, no PC, so there's a release outright. Is there a stay away order?
Yes, Your Honor.
Hold, correct, Your Honor.
Yes, there's a felony hold for the other case. And sir, you're ordered to stay away from Lana Montgomery, to have no contact with her. Christopher Davis. After this case, I need to take a real quick break. No, we're almost done, but I have to take a break. Mr. Davis, you're charged with possession with intent to sell suspected ecstasy, possession of more than 20 grams of cannabis, possession with intent to sell cannabis within 1,000 feet of a church or convenience store, resisting arrest without violence, Are there any concessions on probable cause state?
The state would agree there's nothing within the affidavit about being within 1,000 feet of a church or a convenience store.
Okay. Any arguments from the defense?
I would just stipulate to state's finding, and that's the count 3, to clarify?
I think it's both counts 1 and 3, right?
I believe it's just count 3. Your
Just
Honor.
count 3. But no PC for aggravating factor. Count 1, the bond will be set at $5,000. Correct.
I believe so, Your Honor.
Count 2, $2,500.
Yes, Your Honor.
Count 3, also $2,500.
I believe that would be 5,000, Your Honor.
But that's where you agreed that it's not an F2.
You are correct. My brain has stopped working.
I understand. I'm with you. Why wouldn't they be duplicative then? Are there different packaging? State. What's the difference? Why are there counts 2 and 3? This is why the court needs to take a break, because I'm like,
I believe count 2 is strictly for the possession. Count 3 was the aggravating factor for being near a church. So given that there was nothing within the affidavit for the church, but he was still in possession of the marijuana.
count 2 is the possession with intent.
Correct.
It does seem to be duplicative then.
Are these packaged individually? You made a statement it was for personal use, not for sale.
It looks like the A form does not indicate how they were packaged.
Judge, defense would argue for a straight no PC finding for count 3.
And we already have the possession more than 20 grams in count 2, correct?
Correct, Your Honor. We would agree with the fact.
Okay, so they agree, no PC, count 2.
Count 2 is no PC, Your Honor.
No PC release out. No, I'm sorry, it's count 3.
Count 3 is no PC. Count 2 should be $2,500.
Probable cause on count 4. And the bond,
Count 4 should be 500.
the court is going to take a very quick recess.
like 2 hours.
Right. Oh, no, you don't need this.
No, yeah, yeah. It's really fun. I think that's the first time I've ever heard of somebody doing on the third on Ron's calendar. I didn't know what to say. So if we didn't do additions, yes, so I was like. He's like, who's the, correct after that? He was negotiating with the judge. He said 60 and he was about to deny it. He's like, I'm guilty. And then yeah. But I also, I do think Justin Barnaby doesn't have any availability matters. He is homeless, and so that's why he keeps doing it. But he just how you got that, so. I know. I know. How many did you say we have that?
Got it.
Yeah. I hope I'm miscounting.
Okay, Harold Tinker. Mr. Tinker, you're charged with possession of suspected MDMA. I guess that's ecstasy. Any arguments from Mr. Black?
No PC arguments, Judge, just bond arguments.
Okay, what is his prior history?
Your Honor, the defendant does have at least 8 other counts of drug possession, including possession of marijuana and cocaine.
Any convictions?
All of those are convictions.
Your Honor, I haven't been in trouble in a long time for any kind of possession.
I was just about to ask him that. You read my mind, sir. I was gonna say.
I'm sorry.
Hang tight.
The most recent controlled substance conviction was last year. It was an F-24. Or it doesn't say what.
You don't want to say anything.
Okay, I was gonna tell them they found it on the ground and put it.
Okay, Mr. Black, what would you like to say?
So, Your Honor, given the allegations, we'd ask for ROR. He's not a danger to the community. He will return to court. The bail statute, there's 3 questions. Will this person show up to court? Are they a danger to the community? And so I don't think there's anything in this A form that indicates that he wouldn't return to a court or that he's a danger to the community. And he's entitled to presumption of non-monetary release.
This is Mr. Tinker. Would pretrial take him or no?
No, he's a 300.
What does that mean? Can I see it correct?
Yes, sir.
You could go to tap. Mr. Tinker, December 23 is not that long ago, so it says that you had a burglary conviction in December 23. So the clerk is suggesting the alternative program.
Your Honor, I'm just going to mute the microphone for a second to ask Mr. Tinker a question.
All right.
Your Honor, he's not homeless. He's got a permanent address on the A form 11051, Southwest 200.
With that,
Yeah. Top is not on the phone.
my clerk is telling me that they would consider taking him even though he's not homeless. Thank you.
I think in that case, just to be safe, we should ask for PTS instead of TAP.
Well, PTS said they won't take him.
And why is that?
They said because he's a signal 300, he has a prior history.
Got it.
Well, I'm gonna try the alternative program with the alternate bond of $2,500.
Your Honor, I'll just ask, I'm just a little concerned about the alternative program. It usually takes a long time, so I would ask for GPS with an alt bond at his physical location, his physical address.
It only takes a long time if they don't have the address.
He has an, is this his correct address?
Yes, sir.
Okay, okay,
Let's try it.
if they say so.
PC, the alternative program, alternate bond, $2,500. Timothy Holmes. Is this Mr. Holmes? He's also charged with possession of suspected MDMA. This A form is identical to the last one. Okay. Now find probable cause. Mr. Black, what would you like to say about it?
Judge, I see that there's PC within the four corners of the A form, but oddly, it is the same exact narrative as the prior defendant.
I saw it. What would you like to do about the release of Mr. Holmes?
One moment, Your Honor.
You have his record state?
I do, Your Honor.
So Your Honor, he does not have the money to bail out through a bail bondsman.
Of course, she's got counsel.
We'd be asking for PTS at his mother's address.
The correction statement?
Yeah.
Okay. Yeah. Okay, pre-trial services with an alternate bond of $2,500.
That means they're gonna let you out. Just give him, you give him your.
Thomas Wesley Jones. Mr. Jones, you're charged with escape, resisting without violence, and trespass to a structure or conveyance unoccupied.
And defense has PC arguments, Judge, just heads up.
Read the argument, read the A form first.
Your Honor, he's out on felony bond F251122.
I have it on my pink sticky post-it note that the clerk has forbidden me from removing. Defendant was arrested for trespassing. While handcuffed and under arrest, the defendant took off running from officers, pursued him on foot. Subject ran all the way to the Trader Joe's parking garage. Okay, let me hear from Mr. Black. Unless there's a concession from the state.
Your Honor, I do believe there's probable cause here to arrest the.
Let's hear from Mr. Black.
So, Your Honor, the escape statute requires the person fleeing to be a prisoner, to presently be a prisoner, and to be escaping from a prison facility or a detention facility. It does not account for somebody who's just been arrested, taken off. That's something else. That's the language of the statute.
Counsel, do you have a statute number?
94440, right?
Yes, sir.
The state stipulates that counsel's argument.
See that? Before I could even get to the page, Mr. Black, you were proven correct by the state. So they stipulate no probable cause for the felony, which leaves us for 2 misdemeanors. So the court finds probable cause for counts 2 and 3. But unfortunately for Mr. Jones, he has a felony case. So there's a felony hold for 25-1122. The bond will be, what is it, 500 and 250 state for the other misdemeanors?
It's 500, Your Honor, for the resisting without violence, but 150 for the trespassing.
Count 1 was no PC release outright.
That's correct. Corrections.
And Your Honor, given the felony holds, we'd be requesting dollar bonds.
Okay, sorry. Leave it at the bond of 500 and 150.
And Your Honor, there is a stay away order from the property as well.
We already lost him.
Not today, there isn't.
Brian Campbell Ritzy.
Added charge.
Mr. Ritz, you're charged with battery by a detainee on another visitor.
Sorry, Judge, we have the wrong defendant.
Oh, okay. Brian Carroll Ritz. I have a lot of these charges this weekend.
All the same.
Mr. Ritz, you're charged with battery on another detainee in a correctional facility. This was at the pretrial detention center.
Your Honor, he also is being held on an AC no bond.
Okay, I find probable cause. What's the bond on this case?
$5,000, Your Honor.
I'm going to set bond at $5,000. Gregory Brown. Mr. Brown. Mr. Brown, you're charged with making a false report about placing an explosive device or bomb. The allegation is that you called the City of Miami Police Department and stated you would be pulling up to the Miami-Dade North Shore Police Station with a USPS truck, and we're gonna blow it up. As a result of the call, the K9 unit, and I guess it has to do a sweep for bombs. Department of Homeland Security. No, the Miami-Dade Sheriff's Office of Homeland Security was called. Anything you want to say, Mr. Black?
Stand mute on PC, Judge.
The court finds probable cause. Is there a standard bond discharge?
It is to be set, Your Honor. The state would request a $2,500 bond.
Have priors?
He does have priors, Your Honor, none of them similar to this alleged offense. There's a very remote in time cocaine purchase charged from 1990. That's the only conviction, Your Honor. It was also a conviction for possessing cocaine with the intent to distribute.
All right, the court is going to set bond at $2,500. There's a lot of discussion going on. Eric Andrew Suarez Triana. Sir, you are charged with possession of cocaine, tampering with evidence, and possession of drug paraphernalia. The court will take a look at your arrest affidavit. Says you are observed in a pedestrian mall with a suspect pipe, crack pipe. Stepped on the pipe, causing it to break. The court finds probable cause. Skate.
The defendant does have convictions of petty theft and resisting without violence. We're asking for standard bond, Your Honor, which for counts 1 and 2 would be 2,500, and for count 3 would be 500.
When was his conviction?
M24 is one conviction. The next conviction is an M19. There's an M19 resisting without violence and an M19 drug paraphernalia possession.
Anything, Mr. Black?
Yes, Your Honor. Given that he can't afford to bond out and it's tantamount to no bond to him, we'd be asking for TAP as a non-monetary option.
Can I see the printout? I'm sorry.
Yes, Your Honor.
I didn't have possession of cocaine. Based on his record, I'm gonna just leave it set at the standard bond, which is $2,500 on count 1.
Yes, Your Honor, count one, count two are 2,500,
2,500 count two,
count three is 500.
and 500 on three. Antonio Concepcion the third.
Defendant refused, Your Honor. He's reset for tomorrow.
Right.
I apologize. I missed that. So that was a,
How many days?
Reset for 310.
I'm so sorry. I'm sorry, there's,
Mr. Black, are you okay?
I'm sorry, Judge. We're fine over here. I just missed what happened with Concepcion.
He refused, reset till tomorrow.
Thank you. Thank you.
And the last case I have is Islay Chacon.
He refused, Your Honor. Reset for tomorrow as well.
All right, reset 310. Thank you, corrections.
Let's have a response score. You get the response score.
He's trying to be someone. He's not succeeding, but he's trying.
Judge, do you know if there's anything over on the dependency side, or we're done?
Done.
Done. Okay.
And we're excused over here, Judge?
Yes, thank you for your hard work, Mr. Black.
Have a great day, Judge. Thank you, State, for the PC concessions.
Thank you.